Please, your lordship. Lordship, therefore, listing a AB lordship and leftover metal lordship on 28 lordship. Can it be lordship on Friday lordship? There is no interim lordship. CD is here.
AB only.
Lordship.
What is the urgency? AB only.
Lordship, interim is not there, lordship.
Otherwise, also AB only, it cannot be considered as a so urgent.
Lordship, CD is available, lordship, and can be Friday.
Maybe on Friday.
Friday. Published.
I have a similar claim, right? Maybe on Monday, my lord, I have to. Because this was last 18th.
Oh.
My lord,
And another, my lord, criminal appeal, my lord. 2.5 years in custody, jail, my lord. Earlier, it was listed before lordship, but not reached.
Not
It
reached.
is on 12th of August. Appeal,
12th is that Tuesday?
my lord.
Tuesday, okay.
Hearing.
may I please, your time? I'd like to mention for listing a bail application, my lord. 90 days is statutory period that is over for default bail, my lord. Tomorrow, my lord.
What?
Then day after tomorrow.
Friday.
My prayer also lordship for listing Friday, regular bill.
আপনি ফুটিয়ে এসে বেশি হলে বেলেগত যাব না যাই না না এটা মেনশন ম্যাটার নেই ফিক্স ম্যাটার হবে না কালকে ফিক্স করা না না যাই যদি মাস সব ক্যান্সেল করে দিও তাহলে খবর করে দেবো ফ্রাইডে ইমান ম্যাটার থাকবে না কথা মানে ওকে
Friday, lordship. Lordship, another prayer lordship. Item number 16.
16
16 lordship, regard to that item lordship. Here lordship, coordinate bench of this honorable court has in a series of matter has decided pass the order. So may I pray this matter may be placed before court number 16 on Friday.
no I don't know what is the nature of case
Nature is
the
regarding
special act under special act any
not special act. But
okay you made a request before raised we cannot direct the report
then lordship pass
and the request will purpose
pass over
and the
that.
request made by the non-constitutional petitioner leaves the matter as on a date to be fixed by the registry. Okay.
Pass over.
Mayor, please, Lordship. Item number 21. We just received the file 2 days ago and we are about to file Vakalatnama. So we need 4 weeks' time. Item 21.
You are for the respondent.
Respondent number 2.
But have you informed the other side?
Yes, yes.
You are for the petition. So copy you have received only. What you have received
The
yesterday?
file has been transferred from the previous council to us 2 days ago. So we are yet to file the Vakalatnama. And she is posted out of Guwahati in Arunachal Pradesh. So she'll come on 8th, then sign the Vakalatnama, and then we'll be able to file the Vakalatnama. Not 8th, sorry, 10th. 10th, I think she'll come. And there's
And
another.
you are Mr.
Yes, Islam, lordship.
S. Islam.
Yes, lordship.
We are praying for
21.
4 weeks'
I
time.
heard Mr. S. Islam, the learning counsel for the petitioner. And also heard you are MS?
Yes, I can.
A. Sakya. The MS A. Sakya appearing on behalf of the respondent submitted that they were newly engaged in the present case and Vakalatnama is yet to be filed and accordingly she wait for some more time for court. Prayer allowed, list the matter accordingly after 1 week. Okay, after 1 week it will be listed as on a date to be
After
fixed by
4
the
weeks. After
After
4
4
weeks.
weeks in
Because she's coming on 10. And then we will be signing she'll be signing the Vakalatnama and then we'll be filing it.
you will be 4 weeks will be okay.
No, 4 weeks, why we are praying? Because they
4 weeks
cannot,
will be okay for you.
3 weeks, maybe 3 weeks.
Okay, 3 weeks. We cannot accommodate your client in that manner. 3 weeks.
May I please, your lordship? I beg to mention item 48, lordship. Probably CD is not available, lordship. May I pay for fixed further date?
Case diary you have received.
Yes.
You have received the case diary.
I'm sorry, lordship.
May I plead your lordship?
Your case diary has been received, so it will be on at the it will be called for.
Yes.
I beg to mention for listing of a Abbey lordship, which I have filed yesterday lordship, for day after tomorrow lordship.
No,
Friday.
sorry, Monday.
Lordship, kindly.
Monday.
May I please note? I'm praying for listing her bail for withdrawal matter tomorrow.
Huh?
Withdrawal matter.
Huh?
Withdrawal. Tomorrow matter.
my lord,
This case I have filed on 25/7, my lord. That's why I'm praying, my lord, to list this matter tomorrow, my
No,
lord.
sir, not at all.
Day after tomorrow, my lord.
No, Monday. What kind of matter?
My lord, this is BA.
Monday.
Obliged, my lord.
And I heard it.
May I please, your lordship?
একটু কি চলিয়েছে বলছে বন্ধ কর এটা বন্ধ কর। ডাইরেক্ট লাগে তো ওইটুকু আমি এইটুকু ইয়েস
May I please, your lordship? My lord, in this case, I am 46 days in custody, lordship, as on today.
46
46 days, lordship. And the allegation is theft, lordship. The co-accused has already been enlarged on bail in 3 different bail petitions. 4 accused persons are already enlarged on bail. Lordship, may kindly see page 19. I have annexed the order and they were enlarged on bail on the motion day itself, Lordship, may kindly see.
Page one, page one,
Page 19.
we have the DNA page.
Hmm?
It's not annexed to online.
Okay, below.
No.
ইয়েস
Lordship, might be on the, might be not on the same footing and moreover, Lordship, they have not annexed that copy in my petition.
ডু ইউ হ্যাভ এনি এক্সট্রা কপি
Oh, sorry, Lordship, I don't. I will serve a copy, Lordship. Yeah.
Lordship, kindly call for the case very short, that may be given, Lordship.
Lordship may be taken after some time. I will, in the meantime, only Xerox copy I will provide to my learned friend. Already co-accused are 3 petitions are there, Lordship. 3 different petitions, 4 petitioners are enlarged on bail on the motion day itself, Lordship. After some time, Lordship, I will provide copy. Obliged, Lordship.
May it please your lordship. Lordship 483 petitioner, your lordship. Petitioner is behind the bar since your lordship. 13/6/2024, your lordship. Here in this case, your lordship, the first informant is a teacher working at Nagarwara School in the district of Kamrup, your lordship. An allegation was brought that she was in relationship with the accused person, your lordship. And during that relationship, your lordship, he was subjected to a torture, your lordship, exposing her photos and all, your lordship. And also alleged that he is a drug
Where is the FIR?
drug addict.
FIR
FIR is at place, your lordship. 13 may kindly will look into, your lordship. 13, your lordship. Actually a zero FIR was lost in the Meghalaya, your lordship. So and then, your lordship, since it falls within Bokishto PS, so subsequently got registered by Bokishto PS. Case 13 may kindly be looked into, your lordship. May I read, your lordship? With reference to the subject cited above, I, Dulenthi Pongsit, would like to file the first information report on harassment of my boyfriend, Mohammed Mr. Asik Iqbal Latif, since we are in a relationship for like 1.5 years. On the 12th of March 2025, I left him because of harassment and exposing of the unwanted photos from my phone, and he is also drug addict. For your information, I'm a teacher in Nagarwara School and I have done the report of the affair of Nagarwara, but because of election time, there is no reaction behind my application here. So this allegation is totally false, your lordship, because as this is a rude behavior, your lordship, because of some trivial issues, your lordship, sometimes used to pick up quarrel by both of them, your lordship. And ultimately, eventually, when the accused was assaulted, your lordship, so that day he decided, your lordship, that it's not possible to enter into marriage with the victim girl, your lordship. So that's why this allegation was brought, because the relationship is for long, your lordship. But I have tried my best, your lordship. But because, sir, it's a lead up to climax, your lordship, that not possible to keep the relationship with the girl, your lordship. That's what I have decided, your lordship, not to. 47 days as on date, your lordship. So considering the period of detention, your lordship.
Kindly come to page 15. Paragraph number 5, Lordship. May I read, Lordship? During the course of investigation, the accuser served notice and called upon to appear before the investigating officer for examination and cooperation. However, he willfully failed to comply and instead created a fake Facebook account under the name A.G. Mukherjee and used it to disseminate objectionable content targeting the complainant. And thereafter, Lordship, 7, during investigation, the accused mobile phone used to create and operate the fake Facebook account was recovered from a concealed location. The device contained objectionable material and evidence linked to the harassment. Lordship, it's an admitted fact there was a relationship between the complainant and the accused. But that those obscene photographs he has been circulated in the social media, that is a crime. First, you may call for the case diary. It's from Kabul Petro only. A very short it may be given.
Your lordship, 47 days today, your lordship.
Let it be on Monday.
Your lordship, sexual, 75 there is sexual harassment, your lordship. Both of them are major, your lordship. I am also not denying the fact that I am not in relationship. your lordship.
Relationship.
Relationship is there,
The
that's not.
photographs in the social media, that's a crime.
But as per this, is there any his mobile handset, etc., those were already seized by police?
Lordship,
Already seized.
already seized.
Only considering the period of detention, your lordship may consider it. Otherwise,
Fix it on Friday or Monday.
prima facie, there is a case, I am not denying, your lordship. But your lordship consider the detention because 50
Already
years.
47 days, Lordship, on Friday or Monday. Lordship. Whichever is convenient is from Vasistha PS. Lordship.
No, short date is not possible.
On Monday, Lordship.
Monday. Figure, no? On Monday, your lordship.
Good better. কিমানটা হয়ে আছে এটা?
Friday.
এটা একটু নিদিব ন দিবই বুজা নাই কিমান হৈ আছে বাপ ডাঙৰ কথা Fourth, fifth, we don't cannot.
Lordship,
At best sixth.
Lordship, on 6th.
Six.
Obliged, Lordship. Thank you.
Obliged.
Wait, please, Lordship. Lordship, Learned Counsel A.K. Bhuyan is on legs. Maybe pass over the matter for timing.
Oh.
Please, Your Lordship. Lordship, in this,
You are appearing on item 4.
yes,
Mr. Thakur is appearing on which item?
4, I came to withdraw my lord.
Lordship, the engaged counsel already issued a NOC that another counsel, if he has, doesn't have an objection, that if another counsel has plead this case.
Counsel was Mr. Thakur only.
No, Aru আছে. Some other also is. But colleagues.
And accordingly, I have on the last, yesterday, I have filed my Vakalatnama also here, Lordship.
Which I have to take this action on. Whether withdraw or not. Because.
Are there the name of 1, 2, 3?
Yes.
Mr. Mehdi's name is also there. One Ardhar and K. Thakur.
Rakesh is also.
So from your chamber, most probably any objection, no objection was given.
Yes, Lordship, this is the knowledge.
If it is on your, between you, I don't have anything to say there. If it is all right, no objection is there, then so you can appear. Yes, Mr. Thakur. So you are not going to appear. So what is your good name here?
Lordship D. Bormon.
D. Bormon. Name is not reflected because
Yes,
have you filed your Vakalatnama?
Yes, Lordship, yesterday.
When? Yesterday?
Yes, Lordship.
D. Bormon, na?
Yes, Lordship. Lordship, I kindly peruse the page number 13.
Will peruse the case. Vakalatnama is available here in the case record.
I did not verify the records, Lordship.
Then how can you submit now?
Kindly peruse the page number 13, Lordship.
We'll peruse the case number. How can we use your submission? We have to hear your Vakalatnama is not available with us. Nothing is with us because you are saying that you have filed your yesterday your
Yes,
Vakalatnama.
yes.
আমি পাইছে নেকি Vakalatnama? Other file আছে নেকি তেখেতৰ Vakalatnama? It's not before us.
Eh,
Because this is the first day,
Lordship,
the motion day.
if possible, kindly fix, kindly matter maybe heard for after some time. In time, I collect the acknowledgement, Lordship.
No, I mean, your petitioner is in custody since when? 7/7?
Yes, Lordship, 18/7.
18/7.
18/7.
18/7, Lordship.
Okay, we'll call for the case day. We don't write anything in the meantime. What is the
Lordship.
nature of case?
Yes, sir. Exactly. What happened in this case?
Trafficking of a person.
Pardon?
Trafficking of a
Trafficking
person.
Of a person. Lordship.
Trafficking.
Yes. But in this case, what happened in this case actually, Lordship?
But is the person already recovered or not yet?
That is not.
Person has already been recovered here.
But that is not here in the FIR. I mean, as per FIR, the person trafficked, whether he's been, recovered or not yet.
In the forwarding report itself, reflect, Lordship, the victim has been
Already
recovered.
recovered.
Yes, Lordship.
Also forwarding for also.
By the way, yes, Lordship, kindly page the page number 15. May I read, Lordship? Order dated 18/7/2025, Lordship. Accordingly, the victim, Koinir Begum, has been produced before the being escorted by WBC 824.
Yes, she is already recovered.
Yes, Lordship. Lordship, what happened in this case actually? The petitioner, accused petitioner is a resident of Haryana, Lordship. Lordship, and he is a stammer and he could not talk properly, Lordship. One day, Lordship, what happened? Father of the petitioner found the victim in the nearby road. Hereby, they have given shelter her. After passing of 5 days, they have decided to got married with the victim. And therefore, they have executed a deed of relationship, live-in relationship on Lordship 11/4/2025. Kindly peruse the page number
Okay,
20.
we're calling for the case diary.
Along with.
As
GCBNS.
because we are not received your Vakalatnama also.
Lordship.
Anyway,
Lordship.
should be called for
And victim statement under section 183. Yes.
along with.
Yes.
CDB called
Lordship.
for along with the statement of the victim recorded under section 183 BNSS, if any.
Lordship, as per the contention of the FIR, Lordship, it has been reflected that the victim was absconded on 18/5/2025, Lordship. But whereas in the deed of relationship was executed on 11/4/2020, Lordship.
Let it be on 6th.
We are not, okay,
Lordship,
cannot,
then, as per your lordship convenience.
cannot fix the date of even, the date is full of it. Somewhere, around marriage is some
11, Lordship.
11/7, 11/8.
11/8.
Lordship, kindly interim order may allow, Lordship.
Pardon?
Interim order may allow, Lordship.
It's not a case of intent.
Deeply obliged, Lordship.
May I please your lordship? My lord, this is an bail application, my lord, in connection with Patalgandhi PS case number 87, my lord. Section, my lord, section initially, my lord, it was section 61(2), my lord, 142 BNS. Later on added, my lord, section 1031 and 238A, my lord. Kindly see page 20, my lord. My lord, there are 3 accused, my lord. As of now, they are arrested. They are not named FIR, but so far as my lord, the record shows that accused number 1 is the main accused and perhaps the only accused, my lord. And we two petitioners are remotely not connected, my lord. Only on some remote suspicion we are arrested, my lord. And now today it is 97 days, my lord. Today, my lord, one more information came to me, my lord. The charge sheet is filed, my lord, by 108 number, my lord. So, my lord, also lower court rejected my bail, my lord, at 97 days. So, my lord, kindly, with a short date, my lord, TCR, my lord. And your lordship will decide in examine. I'm not insisting today on
So
anything.
after the charge sheet, have we approached the learned trial court? bill?
My lord, just before that, my lord, I approached my lord and it was rejected. My lord, annexed the copy, my lord.
No, after filing of the charge sheet, have you appeared?
No, my lord, but the other person has, my lord, the file, this not granted. The co-accused,
Ah.
not granted. So, my lord, kindly, my lord, TCR may be seen and short date may be given only.
We don't.
Lordship,
My
after
lord-
filing of charge sheet, perhaps the petitioner has not
Yes.
appeared before
My
the
lord,
trial.
my lord, co-accused, my lord, has
Let me
already
Be
filed.
under apprehension, then your petition may be rejected. How can you
Lord-
say that?
My lord, other
Not
accused,
these.
my lord, already rejected, my lord.
Your petition is not been rejected after
Yes.
filing of the charge
After
sheet.
one charge, my lord, it is just recently filed, my
Might
lord.
not be on the
Just
right
filed, my
motive.
lord. So kindly, my lord,
One thing.
my lord, TCR may be going to kindly maybe
We
examine.
discuss the
my-
matter with the administrative team
Matter-
because we are now, I have seen that in many cases, without even approaching the learned trial court below, the cases have been filed.
No, my lord, kindly, I have
The
annexed, my
petitions have
lord,
been
my
filed
lord,
here.
my lord, I have annexed the orders.
This is not
I
fair.
I have annexed the
This
orders.
should not be. This should not.
Kindly see, I have annexed the
And
orders, my
even
lord.
after suppressing some of.
No, my lord,
the
I have annexed the
evidence
orders, my
filed.
lord. Kindly see, my lord. Kindly see if the page number, my lord, at page 30, my lord, 57, my lord, kindly see.
Charge sheet, do you have any instruction
No
in regard to
instruction.
filing
till
of the
date,
charge sheet?
Lordship. We'll take the instruction. No instruction.
This charge sheet number do you have?
Yes, my lord, I have come to know just this morning,
No,
the lower
charge
court,
sheet number
the
do you
lower
have?
court, my lord, lawyer
Do you
instructed.
have the charge sheet number?
Yes, my lord.
What is the number?
108, my lord.
CS 10
108, my lord.
dated?
Date, my lord, could not be given, my lord.
How can we say? Take
We'll take
instruction.
the instruction.
Today only you're going to take the
Yes,
instruction.
Lordship, today.
At 2?
At
At 2?
2 p.m.
My lord.
Right, please.
Yes.
You know, the petitioner is an engineer in the PW department.
Hmm.
Under him, there was a lady who was working as an assistant engineer. After I was transferred from the place, the lady committed suicide. And thereafter, my lord, they have sister filed an application, FIR, alleging that for the abatement of the petitioner, she has committed suicide. You know, dear, one
Where
aspect
is
your
the
lordship
FIR?
is
FIR is at page?
21.
FIR is at page?
21.
21.
You know, before that, what I say, committing suicide is a mental state of mind. How, unless there is some physical force or physical factors, how one can obey. Our case is that she was harassed because of the official work. Not only she has grievance against about 3 persons. Lordship may kindly see page 21. What it is? Let's try that.
Page 21, Mark. With due respect, it is stated that today when myself, my mother and family members were calling my sister Joshita Das, who was working as assistant engineer PWD Bongaigaon subdivision, but she did not take up any phone calls. Then we got in touch with her landlady and her other acquaintances at Bongaigaon. And when they entered her house, it appeared that Joshita Das had committed suicide in her residence near Niara petrol pump, Borpara, Bongaigaon. With regard to the suicide, she was under tremendous undue and illegitimate work pressure from her seniors, colleagues, contractors, including architect Devojit Sharma of MS Aesthetics Creations, SDO Amirul Islam, that is myself, executive engineer Dinesh Medhi Sharma, regarding some mini stadium project. She was forced, coerced, criminally intimidated, and threatened to prepare and pass estimates and bills in irregular manner, which took a severe toll on her, for which she had to take this extreme step, and thereby putting an end to her life. It is pertinent to mention herein that from the last few days, my sister Joshita Das was informing me as well as my parents regarding the illegal pressure and demands, and she has been facing from her seniors, colleagues, contractors, etc. She further disclosed before us that her seniors, colleagues, contractors, etc. were asking her to do some works which are against the work policy of the department, and when she objected or fails to do the same to them, they ask them to leave her job and or ridicule her being incompetent in her works. When she disclosed the undue work pressure she had faced to her seniors, they also did not help her, rather rebuke her and ask her to do the works as per their wish and also harass her mentally. The information which was conveyed to me and my parents by my sister Joshita Das regarding the undue workload and illegal demands she had faced in her office prior to her death forced Joshita to take this extreme step, as she had no other option had left to her but to end up her life. I therefore request you to investigate the matter and appropriate action.
Now, your lordship will kindly see, this fellow was transferred in June,
Wait, the date. Page 14, my lord.
page 14,
2014.
24th June, page 15. Your lordship will find my name. First one, page 15. In the interest of public service, this man was transferred to Guwahati. And the FIR was filed. I joined in 7th July. FIR was filed in 22nd July. That apartment, no? She has named so many persons on whose overtax she has committed this. It's actually a state of mind. It's a case of abatement. Abatement must be something physical.
We want to say always it should be physical.
Physical.
Is it a case that the abatement always should be in a form of physical?
No,
Is
in case to case, it may vary. But suppose she is alleging against about 4 or 5 persons. Everybody has cause. Which one has led her to commit suicide? And they are government servants, all of them. She has not alleged any particular act to any of the accused persons. But this is very serious thing in the sense that somebody will commit suicide and I have to visualize because of this. The government service is the subordinate officer. So I have to point out in the official duty. Somebody gets disturbed by their body. Well, which one?
No, but it is basically stated in, I don't know what is the entire note in the suicide note. But
Yes.
plain reading of the FI, it shows that she was under pressure because she was harassed and mentally pressurized to do some illegal works, especially in passing those bills and all. That is the issue. I don't know whether it is true or false, but
But
that
why
is the
after so many
allegation.
days, I was transferred.
I don't know
Because
what is
there's
your
a
involvement.
21st.
Involvement at this stage, we cannot say only perusing the
Here
FI.
my lord, your lordship will only consider whether the possibility is there. So many persons, FIR was filed after I was transferred and joined about 14, 15 days.
Incident of 14 days.
After 14 days. And
Yes.
for this, my lord, no custodial interrogation and all these things are necessary. And moreover, my lord, your lordship has come to know that recent decision regarding grounds of arrest and reasons of arrest. Grounds of arrest, of course, was furnished from me, but I do not find any reasons of arresting me. So if, my lord, something can be shown that these accused persons talk to each other in order to influence her mind, that way it is a very difficult situation, ma'am. So in my respectful submission, my lord, lordship kindly grant them bail. If your lordship calls, please interim may be given.
Yes.
Lordship, since the contents of the FIR depicts the fact that the prima facie case is made out against the accused persons, including the present petitioner, Lordship, and Lordship kindly come to ground of arrest page 25, Lordship, Annex of 5, round
Page
number
25.
25, round number 1, Lordship. During investigation, and suicide note has been seized from the rented house of the victim, where she has committed suicide. On perusal of the suicide note, it comes to light that the arrested accused persons are responsible to compel her to take the extreme steps they baited her to commit suicide. And therefore, Lordship, the accused persons are the immediate reporting authority of the deceased of the office where the office the deceased had been working. From the statement of the relatives of the deceased, it comes to light that the accused persons had been undue pressurizing the victim since 8 to 9 months, just prior to his transfer from the earlier place lordship, just prior to the occurrence, before 8 to, she has been continuously pressurizing by the present petitioners. Undue advantage was taken from her since 8 to 9 months prior to the occurrence. Lordship. So lordship, at this stage, I'm insisted on calling for the case diary, lordship. CD will reveal everything, whether it is a false case or true case.
What made
So
her,
kindly give us a short date.
what
from
made
both
her to wait for 7 to 8 months? I have my own superior officer, chief engineer is there, but these are the hazards of the government service. Anybody can do that.
Yes, Mr. Nawaz is appearing for informant.
That's fine.
You are going to file the comment?
I've already filed.
You have filed?
I've already filed the Vakalat. I filed.
Ah, yes, yes. Okay.
Let the case diary come up, things will be cleared up. Whether the petitioner is responsible. At the end of the day, your lordship will say whether the proximate cause of the death was caused by the petitioner's actions or not. Case diary, only case diary can reveal that part. He's innocent. Otherwise, from the suicide, forward report, if there is a suicide, specifically allegation to be made either. The minority lordship will examine the suicide note. If he is responsible for causing you, because at the end of the day, every act of suicide matter is always caused by mental coma. So whether I am responsible for, whether he is responsible for causing mental coma or not, that is the issue which is suicide. So at this stage, matter, is there an important lordship example?
How do I know, which cause her trauma? It
That's
all
why
depends.
the need of perusal of the case diary is there. Because from
No,
the.
your lordship may
because
call
we
for the
cannot,
case
say
suicide
anything.
note, but even interim one. They are already in custody.
Lordship,
Heard Mr. A.K. Bhattacharya, learned senior advocate, assisted by Mr. A.K. Bhattacharya, learned counsel for the petitioners, and also heard MS H. Bora, the learned additional PP appearing on behalf of state respondent, and Mr. S. Nawaz, the learned counsel appearing for the informant. Considering the submission made by learned counsel for both, I find it necessary to call for the case diary. Full stop. Is the matter accordingly. See,
On
we are
14th
facing problem with short date now.
on 14th of August.
That will be too late. 14th of August is Bongaigaon. One phone call will.
Bongaigaon is different. We are facing different problem. Actually, 8 to we cannot fix.
11.
On 12th, lordship.
8 of is of Bongaigaon. 12.
11.
12.
11th.
12. Okay, 12th of August.
Highly offensive.
My lord. Item 50, my lord. Oh, it is of the same case. Item 50, my lord.
1-5.
50.
Co-accused.
50, my lord.
50. Same,
Yes, ma'am.
same.
Yes.
50.
50, my lord. Supplementary list, my lord.
50 also under same footing.
Same.
Who is he? Dinesh Chandra.
He is, my lord, he was the
Dinesh
executive
Sharma
engineer, my
Mehta.
lord. Thereafter,
He
has-
is an architect or what? Who is he?
he is the executive engineer. He was the executive
He
engineer.
was the executive.
And thereafter, he has been promoted and he has been transferred on 2nd of, he has left the force, my lord, on 5th, my lord.
5th of July.
Yes, my lord.
So
Senior
since
counsel,
8-9 months, he was also harassing her.
In fact, my lord, in the social media, that my lord, suicide note, it is there, my lord. What she stated, definitely CD is necessary, my lord. What she states, my lord, that she was unable to cope with official work pressure. And she also stated that she was under duress because, my lord, she was not having experience. She has been entrusted with such a huge project, my lord. So definitely, my lord, all these things might have also influenced her, my lord. Definitely unfortunate incident. And these two petition accused persons were there around 57 years on the verge of retirement and blame is free career, my lord. Not a single act of some illegality or criminality on their part. Definitely, Lordship would call for the case that and see it. And
So
our
at the verge of retirement, he is
57
now
within 2-3 years.
practicing the corruption practice on what?
My lord, corruption kindly see not a single case against them till date. My lord, work pressure, she has specifically stated in the suicide note
Work pressure is all right. Work pressure may be there, but there are some undue pressure
Mal-
on her.
my lord, whether
That is the issue.
everything, all aspect needs to be seen by this court because
Oh,
honorable.
we also fixing same
Yes,
date
yes,
on
yes, yes.
12th of August.
Yes, yes, because these are
Will be called.
arrested, that's why, my lord. It is not an anticipatory bail, my lord. Those
No, no.
both are arrested
You got arrested when?
recently, both same custody,
Same spot.
same dates, my
Okay.
lord.
We're listing it on 12th of August.
My lord, highly obliging. Much
CDP call.
Yeah, different people react differently in a particular situation, my lord. Kindly see, this is a one of a kind, my lord. We have also not find in our limited experience, my lord, that this sort of cases are because of bills and all somebody committing suicide, my lord.
Obviously.
Everything lordship may see, my lord.
Obviously.
Much obliged.
Obliged.
Because in such a situation where one may not take such steps also.
Yes, yes, yes.
That depends.
She might have left the job or she might
Yeah,
say,
yeah,
she might have
there are some
written
other
a
options
complaint to
also.
the superior authorities. All these things may be considered, my lord, subsequently. My lord.
Yes, lordship, that.
Obliging.
One,
Please.
for some time you are seeking some time, I think.
Lordship, no, Lordship, actually,
Most of the time.
annexers,
You,
no, Lordship,
you are
annexers are not concerned.
seeking.
Lordship.
No, no,
Yes.
why it is time being?
Lordship, annexers of the petition was not available there in this.
Oh, acha, acha, acha. Now you have provided?
Lordship, I have.
Okay.
Gone through.
Only the petitions are there, Lordship. On the motion, the other petitions were disposed of, Lordship. 3 petitions were disposed of.
Now your
allowing for,
petitioner is in custody since when?
46 days, Lordship.
Now
46.
as on today, 46
Lordship, and
days.
they were enlarged on 10-11 days, Lordship.
That we cannot
Because
say.
because the
Why they
vacation
were
came in
enlarged?
between, Lordship, we could not approach.
I am
Lordship.
not in a position to say anything.
Lordship.
So basically it's a case of
Basically 305 theft, Lordship.
Theft
theft
Lordship.
in a dwelling house.
30.
from a jewelry shop
In a dwelling house. Lordship.
or from a dwelling.
Yes, Lordship. 305 is dwelling house.
So what are the other sections?
Lordship, it's,
305 is added section.
yes.
No,
305
initially
theft
it
in
was registered under. Oh, acha, initially it was. So anyway, but 305 is the added.
yes, Lordship.
What is 61 to?
61
It's a
to
criminal conspiracy.
criminal conspiracy, Lordship.
Okay. And 2 sections of 3-1 subsections of 317 is also there.
Yes,
3.7.
Lordship.
Yes.
Dishonestly receiving stolen property, Lordship.
Lordship may kindly
Then-
call for the case study at this stage.
Lordship, others are enlarged on long back, Lordship.
Yes,
See,
without informing. the
Four
lordship was
four
called for.
petitioners are enlarged on bail, Lordship.
What about the recovery?
Already recovered, Lordship. Already recovered. And that is
Theft,
also
that's
mentioned in
good.
the order, Lordship. In the order,
Mm.
the recovery is mentioned, Lordship. You may kindly consider that as Lordship.
So you are the prime accused.
Lordship, I am accused number 2, Lordship. It is who is prime, that is not mentioned, Lordship.
Where is the FIR?
FIR, Lordship, may kindly find at page 9, Lordship. Name is not there.
So what is his role at that point of time? That is not clear.
Huh?
What is the role involvement of the petitioner in the alleged crime? That is not also there, Lordship. So how can we say that he is not involved? So Lordship, that's why I'm insisting on calling for the case study.
Assumed I have involvement, Lordship. 46 days in custody, Lordship.
Have you annexed the seizure list also here? Seizure list?
Caesar list. No, Lordship. Caesar's
No,
not.
that is also not there.
Caesar.
No, you are saying that it has already been recovered. That's why I'm just asking
That-
whether
that's not
seizure
there,
list is
Lordship.
there.
That is also.
You have not
Those are
annexed the seizure list here?
recovered, Lordship. The Lordship, may kindly see forwarding report. Forwarding report at page 15, relevant portion, Lordship. The accused number 3 and 4, they are jewelry shop owner. From them, the recovery was made, Lordship. And they are enlarged on bail.
Three and 4.
Yes, Lordship, 3 and
So they are the receiver of stolen property.
yes, Lordship.
But you have committed.
Yeah.
But that
He
is
has
alleged,
received the
Lordship.
stolen properties.
That is alleged, Lordship. That is alleged.
During investigation, that is written.
But then 3
My
and
humble
4 are the
submission-
receiver and you are the
Yes.
person.
My humble submission, Lordship, assumed I have involvement, Lordship, was 46 days in custody, Lordship. 305, it's a main provision will be 305 if they are committed. And 305 is 7 years, Lordship. To 7 years. 60 days, it will be. Co-accused or enlarged that part may kindly be considered.
Lordship, kindly come to page 15.
It
Name
is
of
here
the
only.
accused.
They are the main.
They are the main accused and the person who has got bail, Lordship, his name is not there.
No, nobody's name is there in the FIR. Lordship.
Name of the accused is Mohibul Hussain,
Yes,
Lordship,
n-
and petitioner's name
none of the
is number 5, Lordship.
none of the accused persons' name are there in the FIR.
No, FIR note, ground of arrest in 15 page para.
Yeah.
Page
Yeah.
number 15, it is noted that before apprehension, the accused persons Safikul, that means you are, and Mohibul were
Yes.
carried an iron rod with them.
Yeah.
Then public suspected them and is theft and apprehended them. Before apprehension, the public assaulted. You are also assaulted.
Yes.
Anyway, for
That is my humble submission that I am, I assumed I am involved, Lordship. 46 days, Lordship. And
Okay.
co-accused are enlarged on will that ground may kindly be considered, Lordship.
Heard Mr. M. I. Hussain, the learned consequently branch. And also heard Mr. MS S.H. Borak, the learned additional PP appearing on behalf of state respondent. This is an application, section so and so in connection with so and so. It is submitted by Mr. Hussain, the learned counsel by the petitioner. That the present accused petitioner is innocent. And he got arrested in connection with this case only on suspicion. The theft articles have also been recovered from some of the co-accused persons. And there is sufficient progress in the investigation. As investigation and hence further custody interrogation of the present accused petitioner. When it be required for the investigation. Mr. Hussain further submitted that the co-accused persons, some of the co-accused persons have already enlarged on bail. And considering the case of the present petitioner and the same footing, he may be also granted with the privilege of. Next, where MS Bora, the learned additional PP submitted in this regard. That this petition, the present petitioner is the prime accused who committed the theft and they committed the theft and hence the rest of the case that he will be required to know his involvement in the alleged offense. Next, considering this submission made by learned counsel for both sides, I have also produced the case record and it is seen from the reporting report that there are the present accused petitioner was arrested on the arrested on suspicion that he committed theft on the night of incident. So without going the detail of the merit of the case, considering the ground of parity, as well as the length of detention already undergone by the accused petition, find it a big case to enlarge the accused on so and so steps. It is a case of Bongaigaon
Lordship.
to the satisfaction of CGM. Okay, you are granted it.
Deeply obliged, Lordship.
Please, Your Lordship, I'm for the petitioner. Lordship, FIR is on page number 11. I would like to humbly submit that on night of.
Page number 11.
Yes, page number 11. I would like to humbly submit that on night of 2/7/2019, around 9 p.m. Sri Shiva Musari, who lives near my house, physically assaulted members of his own family. At the time, his mother called my husband, Sri Bir Singh Musari, to intervene and stop the altercation. When my husband went to their house to intervene, Sri Shiva Musari, in a fit of rage, attacked my husband with a dagger with the intention to murder. As a result, my husband was seriously injured and became unconscious due to excessive bleeding. He was immediately taken to Goshaigaon Hospital and later referred to Kokrasar R&B Hospital for further treatment. Therefore, I earnestly request to take immediate action by arresting accused and ensuring the appropriate punishment to given under the law.
May I submit, Lordship? It's a surseated matter, Lordship.
Oh,
So TCR may be called for a distance.
also case as chargesheet.
Yes, yes.
TCR to call for registering with Judy Nero. List accordingly. After 1 week, as in date to be fixed by weeks. So we are calling for the TCR. We are calling for the TCR. Trial court record. List record. It will be listed after 1 week.
Okay, that's-
May I please, Your Lordship? My lord, here in this case, my lord, petitioner has been arrested on 4/6/2025. Today is, my lord, 57 days. My lord, allegation, my lord, some amount, my lord, some amount of rupees 54,32,000, my lord, has been stolen away by the petitioner and his accomplice, my lord. And my lord, your lordship kindly see, all entire amount has been recovered, my lord. My lord, if your lordship go through the, my lord, forwarding report, my lord, page 11, my lord, 11 para 2, my lord. May I read, my lord?
Hmm.
The accused person, paragraph 2, my lord, page 11. Accused person is prime accused who is directly involved in the commission of the crime. The stolen amount of rupees so and so has been recovered from his possession, and remaining amount has been recovered from the possession of his accomplice. Accomplice, my lord, one Divjyoti Burman, my lord. He is also arrested, my lord. From his pawn shop, my lord, entire money has been recovered. And he is admitted the involvement in commission of his crime offense, that is, along with the accomplice Divjyoti Burman, 20 years old. My lord, my humble submission, my lord, since he has been languishing in jail hazard for 57 days and entire amount has been recovered, my lord.
57 days.
57 days. May I pray, my lord, custodial interrogation is not required at this stage, my lord. On the other hand, my lord, I have annexed the, my lord, rejection order. Rejection order also reflects amount has been recovered. Page 13, my lord. 13, my lord. My lord, third para, my lord. May I read, my lord? The accused Nayanjyoti Bora, present petitioner, my lord, was arrested on so and so along with accused Divjyoti Burman after he fled away with the cash van of CM's company containing 2 trunks consisting of rupees so and so. The van was left abandoned and the amount of rupees so and so was found scattered in the floor of the van. The accused was traced and arrested, and he stated that he had planned the theft with the co-accused Divjyoti Burman. Later on, the cash amount of rupees so and so was recovered from his possession, and another amount of rupees so and so was recovered from a pawn shop of accused Divjyoti Burman. My lord, my submission, my lord.
Lordship, kindly come to page 14. Paragraph number 4, Lordship.
40.
Page 14, Lordship.
Acha.
Paragraph number 4. The accused Nayanjyoti Burman was the driver of the cash van
Yes.
with which he has absconded. Rupees 46,45,775 has been recovered by police, but the remaining amount is yet to be recovered. And as on today, what is the stage of investigation? We do not have any information, Lordship. So whether CS has been filed or not, we have to take the instruction. Lordship, kindly fix the matter as per your Lordship's convenience. We do not know whether CS has been filed. It is some of the amount is yet to be recovered.
No, but from him, 1,92,160,
Yes, only that much
and
is
from the
recovered.
other one, 43 lakhs, 92,585.
Lordship,
But still, yes, 46 lakhs recovered now,
and
4 lakhs. is
remaining
yet to-
amount is yet to be recovered.
But why the complainant was, I mean, the van was in an abandoned condition?
Lordship,
Who
containing-
lost the complaint?
containing, the van was containing two trucks. Consisting,
Huh?
the van is containing two trunk, Lordship.
No, trunk is all right. Who lost the complaint?
My lord,
Lordship,
he is the
Lordship,
manager, my lord.
8, Lordship, the fire.
Manager.
He is the,
Pen-
my lord, manager of a company. Company means, my lord, CM Info System of a limited company, my lord.
Yes, Lordship.
Situated
It's
at.
their money only, complaint.
Runs of
My lord.
Lordship.
My lord,
At 2, we can fix it.
Lordship,
We can fix it. We
my
are
lord, a
fixing
short
it.
date may be given by.
No, we are fixing at 2. If chargesheet is not there, may be a case of bail also.
My lord, it will, CD will come from Jalokbari PS.
At 2, at 2.
Oh, my lord, obliged, my lord. I love that.
or can it be on tomorrow, Lordship?
Which one?
Possible. This matter, Lordship, is 8.
We'll make it any problem. We take the instruction over telephone also at 2 let us
Lordship,
see.
Lordship, we'll do, take care.
Because these days, many cases have been
Yes,
fixed and
yes.
we are, like there's some meetings are also going on actually for that purpose.
Lordship.
So on 8, we all are leaving. So by 12 or
By
by
2,
11:30. Oh, so by 2, 12.
Yes.
My please, your lordship.
Yes.
This is an application, your lordship, regular bail application. I am paying for bail
Mm.
to the petitioner, your lordship, in connection with session case, your lordship, which is pending before the district and session judge Nalbari, your lordship. So in this case, what is happened, earlier, this petition was arrested on your lordship's 22/10/2023. Thereafter, he
10.
was 22/10/2023.
Ah.
After he was released on bail. And in the meantime, after investigation was completed,
Yes.
then thereafter CS was submitted before the Allegation state. And in this case, one section is session tribunal. Thereafter, the Allegation state committed this case before the district and session judge
Already committed.
committed. So
So
there are two
while committing, you were appearing.
that
Unless
committed-
you appear, it cannot be committed. I think.
Yes. In this case, committed this case before the session, district and session judge Nalbari, and which is pending now for,
No. At the time of committing the case record, you were there. You were
yes,
appearing.
yes. So what is happened, your lordship, that two occasion remaining absent, but his engaged counsel taken step by filing through petition that you find page number 20,
20,
20.
20.
Annexure 3, 18/3/2025. Accused Tomizal is absent with steps since the petition such and such filed by the engaged counsel stating that he could not communicate with the accused and prays for another date for appearance of the accused. But this learned court below rejected the petition and issued NBW against him, the Tomizali. And thereafter, your lordship's page 21, turn to page 21. And recall petition was filed by the petitioner sides and stating that page number 22, turn to page number 22, is the second line. The accused person has been suffering from various illness like fever recently since 18/3/2025 to 16/5/2025. There are 2 dates only remaining absent, and he could not able to appear before this honorable
Anyway,
court.
the petition was rejected on.
Well,
Lordship, when you come to page 25.
yes, lordship, may I submitting, lordship. 22, this is the-
By order of 18/3/2025, your petition was rejected.
Yes.
yes, thereafter he was.
Then NVW was issued.
In
And
NBW
when you
issue,
got
and he was filed the recall petition. Recall
On the next
petition.
day?
Recall, yes, and that is defined page number 21. Petition, recall petition,
Recall petition was filed.
through his engaged
7.
counsel and 4/7/2025, and
For
that,
the rejection.
Then
that
in
was
the
rejected.
meantime, one date has gone.
Yes, lordship.
because from the order of 18.3,
Aye.
it seems that the matter was fixed on 16.5.
Yes,
But your recall order is, recall petition was, prayer for recall was filed on 4/7.
only 2
In the
days
meantime, 2-3 days have already gone.
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 But as per petition, you see, that.
No, whatever. Then what is the order?
Yes, recall petition was rejected.
It was rejected.
Rejected on 14/7/2026, 25, it was sent to the judicial custody.
So since
And now 26 days behind the bar. So that, and accordingly, one bail petition was filed, regular bail petition was filed,
on 18/7.
18/7/2025. That was also been rejected. Now, as per 18/7, as per 4/7/2025, as on
Considering
today,
your conduct only, those petitions were.
Lordships, there is no ill intention.
No, from considering your conduct, you were absconding, or I mean, not appearing or.
Not absconding.
On his behalf, the petitions were filed, those were allowed. On 4-5 occasions, same thing is happening, and for your non-cooperation only, the case was stayed and the charge could not be framed. That
But
is
my,
your-
my submission is this here, Lordships, there is no any intention to absent.
So why,
because-
on that day,
As because,
on that day, you had.
as because he was engaged.
No, on that day, you were suffering from dysentery and or whatever.
Yes.
But what about the prior dates?
Prior dates, your
Engaging a
Lordship,
counsel
yes,
will
yes.
not do, na?
he was taken step
How
on his engaged
How
counsel.
the case will dispose of? How the
Yes,
case will dispose of? You are engaging a counsel is enough. Your appearance is not required.
Required, your
Then-
Lordship.
What are you saying? Engage
Required,
counsel, and counsel is engaged.
As on today, 26 days behind the bar.
Whatever.
The allegation, your
Submission,
Lordship,
but don't say that you are engaging counsel. Counsel engaged for what?
on the, on 44/7,
Engaging a counsel, you are not, you're not, I mean, you cannot abstain yourself from appearing in the
47
before the court.
2020, 47
For
2020.
your conduct only,
was-
the
I
charge
was-
could not be framed. Yes,
I'm sorry,
Lordship.
26 days behind the bar, your Lordship.
that is okay. That is
The
otherwise.
condition may be imposed earlier, he was arrested.
The conduct of the petitioner is not at all appreciable, Lordship,
Hmm.
because on his part, inordinate delay. this
That is
party
his
escaped
part
before
only. That the
court
order
at the
shows, order
time of
reflects everything.
framing of charge, Lordship, which caused delay in the entire trial proceeding.
Entire trial.
If he,
That too, it is a case of
And-
session tribal case.
And I have found no
look, for
illegality in the order.
evidence, your Lordship,
Has been passed by the trial court.
for evidence 22/9/2025.
Rightly.
The
exceeded
length
the
of detention kindly be considered, your Lordship. Each and
You are
every
Mr.
day,
S. Islam or R. Islam?
as Islam.
Heard Mr. S. Islam, the Learned Counsel for the petition. And also heard Mr. M.S. Bora, the Learned Additional PP, appearing on behalf of State Respondent. This is an application under section 3 in connection. Next, it is submitted by Mr. Islam, the Learned Counsel for the petition, that the petitioner was earlier arrested and granted bail before filing of the charge sheet. And after filing of the charge sheet also, he was appearing regularly before the court. However, in some occasion, he could not appear personally before the court. And through his engaged counsel, the petitioner was appearing before the learned session judge. But on 18/3/2025, the petition filed on his behalf was rejected by the court, and NBW was issued against him. However, the petitioner again approached the learned trial court below with an application for recalling his NPWA issued against him, but by order dated 4/7/2025, the same has been rejected, and since then he is in custody. After said rejection order, he again paid for a regular bail before the learned trial court below on 18/7/2025. That was also rejected by the learned trial court below, and hence the present petition has been filed seeking bail. Seeking bail by the present petition. It is submitted by Mr. Islam that the accused petitioner has not defaulted intentionally, and due to his illness only, he could not appear on the day fixed for his appearance and framing of charge, but he will appear regularly before the learned trial court below and will contest the case if he is provided with the privilege of bail. Next para, MS Bora, in addition to PP submitted in this regard, that it is a fact that the accused petitioner was appearing through his counsel, but due to his absence, the charge could not be framed, and the case was delayed due to his absence, and hence considering his conduct, the NPW was issued by the learned session judge. However, she submitted that the petitioner may be directed to appear before the learned trial court below with a regular application for bail, which may be considered in accordance with law. Next, para, hearing this submission made by learned counsel for both sides, I have also perused his record and especially the order sheets which have already been annexed along with the petition. It is admitted fact that the accused petitioner was appearing through his engaged counsel after filing of the charge sheet and committal of the case before the learned session judge, but considering his conduct, as he did not appear before the learned session judge on several occasions, his petition was subsequently dismissed, and on 18/3/2025, the NPW was issued against him. However, after rejection of his petition, he appeared before the learned session judge with an application for recalling the NPW issued against him on 4/7/2025, which was rejected by the learned trial court. So from the order sheets which have been annexed along with the petition, it seems that considering the conduct of the accused petitioner, his petitions were rejected or being dismissed by the learned session judge. And also considering the delay in disposal of the case due to absence of the accused. Next one. However, considering the entire facts and circumstances of this case, I find that the 26 days of custody is maybe considered as a reasonable period, and accordingly, I find it a fit case to extend the privilege of bail to the present petitioner with a direction to appear before the learned session judge on each and every date to be fixed by the court, and to appear before the court in view of this provided so and so forth. To this restriction of learned session judge non-party. Learned session judge non-party. Okay.
Any condition may be imposed, any condition.
Yes, you have granted.
Yes, okay.
You have granted with bail.
Yes, yes. All right.
May I please, my lord, in this case, my lord, earlier your lordship declined, my lord. It is a controversial Facebook post, my lord, posted page 20 is earlier order passed by your lordship.
Page 20.
21. That was, my lord, petitioner before your lordship is above 40 years old, my lord, and he is a government employee. And he has admitted that, my lord, by mistake, my lord, his minor son, my lord, posted, and he immediately, my lord, deleted it. And perhaps, my lord, police also is not in the possession of this video, my lord. Because
So
he-
there is nothing change in your petition. The same circumstances you have again applied for bail. So anyway, initiate this.
Whether any new ground has taken,
my lord,
Pardon?
whether any new ground has been taken by the.
No, nothing at all. No, nothing.
only, my lord, the period of detention, my lord, 60 days. I think, my lord, 55 days today, my lord.
Today is 55 days.
55 days. my lord.
Okay, you make a inquiry in regards to the filing of the charge sheet. Is it a 50 days?
55 days.
Let's check.
60 days.
No, sorry. Is it a 60 days offense?
60
Yes.
days.
60 days, my lord.
But
Punishment,
the-
Lordship,
just-
not
just-
60 days, it's 90 days.
no, my lord. Because
One is
here,
90 days, I think.
Yes.
no, it here, my lord, for 90 days, my lord, punishment shall not be less than 10 years, my lord. But here punishment, my lord, may be 5 years also.
It's not less than 5 years, which may extend to life,
Yes, my lord.
extend to life.
But for my lord, 90 days, my lord, punishment shall not be less than 10 years.
Here's what.
Provision is very clear.
197.
Yeah, kind of.
So 1133
Yes, sir.
and 1973, all
I
these.
have got my book.
187 or 90 days where the investigation relates to an offense punishable with death, imprisonment for life, or imprisonment for a term of 10 years or more money.
113 Lordship, subsection 3.
Yes, 113.
113 subsection 3 Lordship.
Ah.
Whoever conspires or attempts to commit or advocates, abets, advises or incites directly or knowingly facilitates the commission of a terrorist act or any act purportedly to the commission of a terrorist act shall be punished with imprisonment for a term which shall not be less than 5 years, but which may extend to life, imprisonment for life. Then 90 days.
Again, 197. These are 60.
197 Lordship. It's imputations, assertions prejudicial to national integration. That is punishment is which may extend to 5 years.
Acha. And 352.
352 Lordship. That is Lordship, intentional insult with intent to provoke breach of peace. Here the punishment is which may extend to 2 years, Lordship. Or with fine or with both.
353 also 60 days.
Yes.
So it seems it is a 60 days.
Yes.
So you make an inquiry regarding the filing of the charge. And we are somehow we are listing because he is in 55 days in custody.
Lordship.
So,
Can it be on Monday, Lordship?
so Monday, how many days will be?
Today is 57 days, Lordship.
55 days.
55 days. So Monday will be Lordship.
56, my lord, running.
50?
56, 70.
50.
60 days, Lordship.
It will be 60 days.
Yes,
Let it be on Friday then.
Lordship.
Friday?
Yes.
Diploma.
Friday 1.
Friday is Lordship.
First of
First of,
1st of August.
yes.
Try to get the instructions first.
Yes, Lord.
CDB call for.
Diploma.
Lordship, CD call for us, the instruction.
We calling for it. Yes, there you take the instruction verbally.
Yes,
also.
Lordship.
Because CD may not reach by Monday,
Lordship.
Friday.
Diploma.
May it please your lordship. Lordship, here, the petitioner before your lordship is a person suffering from mental disorder. No section abstract, no.
Yes. Where is the FIR?
Yes, Lordship. Before that, I'm placing some vital facts, Lordship. The petitioner before your Lordship, 28 days in custody, and he is the patient of mental disorder. I have annexed all his medical document, Lordship. He was going through since 2020, Lordship. At annexure, page 19 onwards, the medical documents, Lordship, of his medical treatment regarding mental disorders. This was it starts from page 19 to and all. Here, Lordship, the informant happens to be a nearly 40 years woman, Lordship, and the gist of the acquisition, Lordship, would be pleased to find at page 10. And in my understanding, Lordship, no case has been made out by the prosecution. May I read the contents of the FIR, Lordship? With due respect and humble submission, I state that I, along with my brother, after having our dinner at night, was going towards Alipur Tinyali under the bridge at around 11:20 p.m. when the aforementioned accused suddenly came up from Bahata Chareli and stopped his vehicle near me at Alipurduar. He said, "Oh, your husband called and threatened me over phone and started assaulting me and pulling me by touching my private purse and tried to forcibly take me into his vehicle. As I shouted, the nearby people gathered. Seeing them, the accused fled from the spot and accused caused severe injury to my chest. Hence, I request you to kindly investigate the above incident and necessary legal action lodged." Now, Lordship, the middle word, "Oh, your husband call." This seems, Lordship, the case which has been projected, the accused as a stranger, that is not there. That it indicates that she is having prior intimacy. That is that indication from the affair, and that apart, Lordship.
Is the translated
sec-
one? Where is the original FIR?
Lordship, yes, original FIR and had.
You are
May I
not annexed
please-
here?
I have annexed, but the page seems very clear.
Not legible.
This is the original. The first page, Lordship, will indicate her age, 1989, Lordship.
Age is all right.
Apply to page more type করে দিছো. Page 10. 10. Now here the sections which has been incorporated, Lordship, taking into this fact, none of the sections are applicable, Lordship. And no, what I have been instructed, Lordship, on that unfortunate night, he was coming, and since the vehicle was very close, there was altercation.
What?
Lordship.
Have you read the SMS version?
Lordship, the vernacular is very.
Particular is very, I don't know.
Good,
Two,
না, মই
It's not
certificate
at all
copy দিতে-
readable, Lordship.
ED, ERA,
মানে everything to read.
and
It's
this
not
origin certificate
phone,
copy দিছো, I will give you.
legible.
ফোন করি ডিম SMS?
Yes. Absolutely a false case, Lordship. This man, he's a mental patient, Lordship. And because of some financial disrupt, Lordship, he could not continue with the medication, and sometimes he lost his temper. So the argument heated on that particular day, but the way that has been projected, it's not the case, Lordship. So 28 days in custody since 3/7/2025, and even, Lordship,
Case is registered under which section?
the various section, all non-bailable. This not at
76,
all,
Lordship,
not at all. I have gone through all, Lordship, propositions. Nothing attracted. 126(2), that is wrongful restraint, is bailable. 74, 75, not at all. 143, Lordship. Nothing attracted, Lordship. None of the sections are applicable in this case. And 118, no grievous hurt by any weapon, Lordship. No indication of that any weapon has been used. It is a clear, Lordship, that because of that, Lordship, he was rash driving and some altercation, and this has been projected, Lordship.
But being a person of suppose mental disorder, he was
How
also
can he
driving
run and
quick.
drive?
Lordship, that was because that was the situation, Lordship. He goes sometime that way, become a little impatient, Lordship. That
During
is
night,
why.
he can drive also, Lordship, being a mental patient.
No, what is fact, I cannot deny that. That was the fact, Lordship. That was the fact, Lordship. Cannot deny the fact. That was admission on my part. In fact, he was there, he was rash driving and altercation, and this sort of the story has been projected, and this man now from 3/7/28 days in custody, Lordship. Lordship would justify whether his further custodial detention would serve any purpose. That is my humble prayer, Lordship. Any condition, Lordship, local person, he will cooperate, Lordship.
There's some medical documents they have been submitted here, but don't know whether it was intentional or.
Yes, Lordship.
And the pretext of
In the
his
midst of
mental
night,
illness, whether he has done these
Yes.
things, that I cannot.
And
Otherwise also,
section 62 is also incorporated. Lordship.
Lordship, take now, being the court officer, Lordship, that is has to be justified from the reading of the affair, Lordship, whether this has been from the fact that has been detailed, Lordship. Anything has come up, Lordship. That is my humble
62,
prayer.
62, Lordship, punishment for attempting to commit offense punishable with imprisonment for life or other imprisonment.
What he has done with that, Lordship, that
He's
is that sort of affair does not
intended to-
disclose.
Take away he has intended to take away the girl, Lordship, the lady. And he has also intended to criminally assault her by touching in her private parts. Somehow she has managed her life, Lordship. The intention was not good. And how can be a person being mental disorder can drive a car? Lordship? There's also
That is
Sir.
why.
Lordship,
Okay, then we call for the duita koribo. CDP call for along with the medical report of the this medical report of the accused as to whether he is suffering from any mental disability.
Lordship, may fix
But-
it day after tomorrow, Lordship.
No, we don't have any fixed short list. Nine dete na kana ke
Lordship, kindly, Lordship, kindly, if
Okay.
your Lordship is,
6-8.
Lordship, that would be too longer, Lordship.
It will
Can it be on
we are listing
Monday,
it on 6-8.
Monday, Lordship?
We cannot. It is so one to it. 6-8 to take out of DD. Yes,
Can it be too longer, Lordship? Can it be on 4th, Lordship?
6-8.
I'm obliged. That would be-
Oh, fix one fix for the big income and I thought I will fix no building a lot. Better to should be facing or the way. And the different times position again. And transfer transfer go to say keep criminal tax keep. People criminal good. And the from our people criminal good. People get second. My yes.
My lord may take up this matter after some time as Mr. Ayabuya is led.
Lordship, otherwise a report was called for. Whether any press case has been registered
yes.
against the prisoner, that report we have received.
You have received the report.
Yes.
If he wants to submit anything,
Not-
okay, then we have time.
Yes.
At a report, I say,
11.
report.
There's a report that maybe captains are part of the written.
Report to our report. Report you have already submitted here.
Lordship.
Report to local tax. Right. This one. Timing.
This report was called for.
Report,
Yeah, and
we have received the report here.
Lordship, yes, reference to. The present case is already registered on 25/07/2025 against the accused persons, that is Atikul Haq and Jahirul Haq.
2 persons were here.
Yes, Lordship.
So case has already been raised.
Yes, and that is under investigation in progress, still going.
Is there any when FIR is registered or is there any?
Yes, Lordship, the Goroimari PS case number 66/2025 under section 85, 82, subsection 1, stroke, subsection, stroke 3, subsection 5 BNS, Lordship.
No, no, it's all right. When it was raised?
Registered on 25/07/2025.
2507 on
Yes.
the last occasion.
During the lengthy of-
Acha. 2507.
2025.
Okay, this reported.
And one FIR is submitted by one Ayashmina
Right.
Ahmed. That is, FIR was submitted on 6/7/25. And case has been registered on 25/07/2020.
report.
Last order was on 25.
Yes, that's not.
Report of no, source dia nahi.
It's only tagged with some other document.
Yes, I'm just trying to.
So yes, what is now, so your submission?
Lordship, we are under protection, Lordship. And we have not yet, only now we came to know that the case has been registered. On the other day, verbally, they have said that they have not registered, Lordship. I think we may be protected, Lordship. And Lordship may call for the case diary of that particular case. Because Lordship, this development has occurred after filing of this case, Lordship. The case has been registered, and certainly the court may call for the case diary of that particular case which they have referred, Lordship. And in the meantime, we may be protected, Lordship. And we may also be directed to appear before the IO, and we will cooperate, Lordship, because the petition number 1 is a fisher, and petition number 2 is his father, aged 76 years. And so far as the sections 85, that is 498A, Lordship, earlier CRP, this IPC. So that is a family dispute, Lordship. And in these days, the judgments also coming that in such type of cases, at least some waiting period should be given for conciliation of this matter. Certainly in these matters also, there may be conciliation and the family would have been saved, Lordship. So we may be protected. Until then, Honorable Court may call for the case diary of that particular case.
Anything submitted?
Lordship, since we do not have the copy of the FIR.
No, we do not have.
Yes.
So
Can
we
we-
were not going to give any interim protest
Lordship,
period as bail.
Yes.
Only simple interim protection which was provided to earlier, not coercive section, and then we'll call for it.
Yes, Lordship.
Because we are not in a position to say anything.
Yes,
We are not only.
The FIR is
Yes.
before us.
Yes,
No,
Lordship.
FIR is not.
In that event, we may also file a separate matter attack with this matter also after receipt of the FIR.
Heard Mr. Darakul, learned also for the petitioner, also heard MSH for the learned additional PP appearing on behalf of state respondent. Next, it is submitted by Mr. MS Bora that as per report of the report received from Goremari Police Station, a case has been registered under Goremari PS case number 66/2025 under section 85/82 subsection 1/3 subsection 5 BNS on 25/07/2025 against both the petitioners in the present case. On present case, on receipt of an FIR submitted on 6/07/2025, which was registered by GD number 1919 dated 6/07/2025.
GD number 9.
In view of this, let CTB call for along with the copy of the FIR. List a matter on 16 Paribo. 18 parity.
16/8,
16/8 is the open day.
Lordship.
Also holiday.
16, Lordship. 16 is a holiday, sorry. On 18, Lordship.
18.
Yes.
On 18/8/2025, until then, the interim order dated 25/07/2025 will be continued. Okay, we are only extending your this one, anticipated bail cannot be granted, we don't have anything.
Yes, Lord.
Let us see, it may be rejected also, it will be allowed.
Let,
And it will part of the recorded report received from Swenson will be a part of it. It will be. You're 14. Why 14? 13 Nama till end.
13.
13 also you are appearing, Ulla?
Yes, Lordship. This is also a report of.
You are appearing for the informant here? Okay.
There is a report, Lordship, we have received.
Yeah, so it seems that on FIR has been.
Yes, Lordship.
So till that, we are not, there's nothing in this report.
Lordship.
Obviously, on the basis of one GD entry made in Gorcho PS,
Lordship.
the inquiry was initiated
Lordship.
and it is still under inquiry stage.
Lordship.
But on the basis of that inquiry or on basis of that GD entry, whether any case has been registered is silent.
That is silent.
Yes, anything you want to submit?
My learned friend is appearing for them.
Probably no case has been registered till date.
How many?
No case has been registered till date, probably. That's my information. There we should notice to the accused person, but he has not cooperated. Now, ACM, we had entered into an agreement with the informant for sale of a piece of land and taken an advance of 15 lakh. Now, during this period, he sold the land to someone. That's why I've blocked the.
As per your instruction. So now this is an anticipatory, but we are calling for the report and report received. But as per your instructions also, as per report also, till now, no case has been registered.
He is not cooperating.
You can
Lordship,
cooperate because it is
Lordship.
a case, suppose overall it seems to be a civil in nature,
Yes,
otherwise.
Lordship. Yes, Lord.
So why don't you approach it the police station?
Because Lordship,
Amicably, if it is,
Lordship, no notice under section 41 also
It is- you
has
are now
been issued
received.
to me. And we apprehend arrest, that police may arrest me. So therefore we have filed and court has called for the report as to whether the case has been registered. That they have also not specifically stated before the honorable court that the case has been registered. So only the reference of the GD entry is made before your honor, Lordship. So we are always ready to cooperate, Lordship. Just we need one protection, Lordship. Till appearance or till receipt of the case, that because they have not yet registered, not specifically stated that case will not be registered. They have also not stated that they have
But
issued
yes.
they have issued 41 notice, Lordship. They have also not
Notice they
stated.
have not received. I would say you're not the police
Yes, yes.
officer to say anything.
Police, they have also not stated in, probably they have also not stated in the report that in spite of receipt of the notice under section 41, we have not appeared. Police has not stated, I think, Lordship. So in view of that matter, Lordship may kindly call for a further report, specific reports, and till then we may be protected.
But there are some, statement in the report that they made to, several attempts have been made to examine you or to interrogate you, but you have not
No,
cooperated.
no, Lord. No, we have
it's
not
for report.
received any notice. We have not received any notice under section 41, Lordship. And from there, we have also stated in our petition, Lordship, there are some civil disputes in respect of this selling of land of the government, that is possession, selling of the possession of the land. It is not a Miadi land, Lordship. It is not a Miadi land. That we have not concealed, Lordship. We have stated specifically in para 4 of our petition, Lordship. That is the reason of our apprehension. That is the basis of our apprehension that one Biraj Boru who may file an FIR, and on that basis probably the police is searching on me. So, we are.
Yes, what to
Lordship,
say?
without,
Bora?
registering a case, how can your lordship make grant interim protection?
No,
Because no case has been registered till date.
no case. has been raised.
Yes, so what the report says.
No, but
That
the
is
police,
the issue.
but the Lordship, but the police has also not issued any notice, and police has also.
No, that's what I'm saying.
That-
He is
because,
committing that
if the police
case
says
not
that-
yet registered.
Yes.
If the police says that we are not cooperating,
Simple statement is there that
it cannot be
they tried
viable.
to make you contact,
Lordship,
try to
as per
contact you,
the,
but you have not.
no, Lordship, as per the legal requirement, they should issue notice under section 41.
That
And
case is not yet registered.
Lordship,
Not yet registered. The FIR is not yet registered.
certainly, Lordship, if,
That is only the basis of the GD entry. They may have some preliminary inquiry on.
but
That is there.
they must issue notice to me, Lordship. They must issue notice to me.
That may be there,
It
but
is not. It is not that they will apprehend me, then they will ask me. The legal requirement is
no,
that.
that is not the case. She is submitting that now. Till now, no
Yes,
case has been
yes.
registered.
Yes, Lordship.
That is it.
The report is
That
concerned.
is only preliminary inquiry, and he also submitting that probably from his instruction, no case has been registered.
Yes.
Court may observe that we may appear before them
We
for
may
recording
observe. We may observe.
statement.
We may observe.
etc.
That will be.
Heard Mr. Deola, and also heard Mr. MS SH Bora, Dilanet additional PP appearing on behalf of state respondent. And you are Mr. B. B. Sharma appearing. For whom you are appearing?
Complaining, the one was lost that.
He is also.
It's not quite, not right. Why may not be?
But anyway,
because
you,
no
may be,
FIR
you may be the complainant or the informant. Complainant.
But the
Sharma
informant is,
appearing to the complainant.
but the FIR,
Yes, so,
as
yes,
because the
FIR is
FIR is not there.
Yes.
There is no
So
question of
better-
informant.
Yes.
Not better. It is submitted by MS Bora that he has all the report has already been received from Gorsuk PS. Where from it is seen that on the basis of a GD entry made in Gorsuk PS, Gorsuk GD on Gorsuk PS number, on the basis of a Gorsuk PS GD entry number 28/28 dated 10/7/2025. Initial inquiry has been conducted by police from Gorsuk PS, but till that, no case has been registered against the present petitioner. In that context, Mr. Ullah, the learned counsel for the petitioner, submitted that there is an apprehension of registering a case against the present petitioner due to some land dispute, but till that they have not received any communication from the police, nor any notice is received under section 35(3) PNSS to extend their cooperation in the inquiry made by the office of inquiry made by the Gorsuk police station. However, the petitioners are ready and willing to extend their cooperation if they receive any notice from the Gorsuk station. In view of this, the present AP is hereby stands closed. However, the uh, the uh, the police from the Gorsuk PS may take some initiatives to issue notice to the petitioners if they are required for the purpose of inquiry in connection with GD Gorsuk PS GD entry number 28 oblique so and so so and so. In view of this so and so. So we
One-
made an observation.
One petitioner, lot, here only
Oh,
one.
only one, sorry, petition, only one. So we made an observation that you have not received
Yes.
any notice.
Yes.
They may issue notice if it is required.
Sure, lot. Obliged.
May it please your lordship. No, here is a case wherein it's a 439 application, my lord, wherein my client has been behind the bar for 40 days in jail. May I take your lordship through the affair that starts from page 13, wherein on reading of the affair, my lord, no prima facie case has been made out. Went to the CJ and pointed out rejected sessions, rejected, my lord. I'm reading the affair, my lord. With due respect, I beg to inform you that yesterday at about 5 p.m. I got a phone call whereby I was informed to come urgently, Guwahati, as my elder son is found dead inside the residence of Kahilipara, Guwahati. Immediately, I, along with my family members, comes to Guwahati and reach at 11 p.m. Reaching Guwahati, I got information that a hand note written by my son Pavan Hazarika before his death is found inside his residence. After doing through that note, it is known that my son had committed suicide due to the tremendous mental harassment and blackmail done by 3%, namely so-and-so Ankit Kumar is the petitioner, my lord, Nilay and Vikas Sisodia. Sir, my son is running one coaching institute at Guwahati in the name of Affinity Group of Institutions which specialize in NEET, G and foundation courses. Initially, the said institution was run by my son with Mr. Ankit Kumar, son of so-and-so, which is incorrect. They both had been running the institution for last 8 years. In the month of October 2024, my son informed me that his business partner Ankit Kumar is planning to leave Assam due to sudden death of his father, and Ankit Kumar wanted to transfer the entire property of business of Affinity. Again, it is incorrect. To my son on payment of rupees 90 lakhs. Accordingly, my son told me that he intends to take entire institution in his name on payment of the said amount to Ankit Kumar. It is also known that to that effect, one memorandum of understanding was executed between my son and Ankit Kumar. Accordingly, as per the terms of the said memorandum of understanding, my son had already paid an amount of rupees 31,68,930. It's correct, my lord. And the rest amount was supposed to be paid within the month of July 2025. But surprisingly, said Ankit Kumar, after taking the said money, planned a game and did not left Assam, and he joined another institute at Guwahati. Thereafter, Ankit gradually started a campaign against the Affinity Group of Institutions and tried to spread rumors against the Affinity Group of Institution along with his two fields, namely Nilay Kumar and Vikas Sisodia. Moreover, through the remaining amount was supposed to be paid by him, by my son, Pavan Hazarika, in the month of July 2025, but Ankit demanded the said amount within the month of May 25 or else threatens my sons with dire consequence. Gradually, Ankit Kumar and his two friends started tremendous mental pressure upon my son. On the evening of 19 June 25, Ankit Kumar came to the residence of my son, and there he demanded money and threatened my son that he will destroy the Affinity Group of Institution and compel my son to be a beggar. Moreover, he forcefully took the dog namely Marshall, for my son custody. That dog belonged to the petitioner, my lord. He also threatened my son to pay the money by within 22/6/2025. Otherwise, he'll ruin life of my son. My son had informed me the said incident, and accordingly, with the family members, told him to be calm and told him that we are coming to Guwahati to help him. But due to such mental pressure and emotional blackmail done by Ankit Kumar and his two friends, namely so and so, my son left us committing suicide on 21/5/2025 inside his residence. Therefore, the FIR. Now, my lord will kindly read with that material on the basis of which FIR has been filed at page 27, the suicide note. 27, my lord, the translated copy. Pori, I have no right to seek forgiveness from you. Amidst of all my problems, you were the only one with whom I could share my problems. You were the reasons my life kept going on, but the incident that occurred day before yesterday destroyed everything. My only request to you is to remember the good memories and move on with your life. It is my life which has come to an end, not yours. I'll be watching over Dunu and Aita and the stars above. We could not meet at the end, but you don't lose hope. Sometimes inquire about the well-being of my mother and others. If possible, forgive me and remember your last words, and have to courage to keep moving forward in life. I love you. Mentally, I am destroyed. I never got tired of working hard, but Ankit Kumar could not digest how an Assamese person could be the owner of a coaching institution. He was someone who I was with through thick and thin for last 8 years. And today, with respect to me, we never allowed me to run the institution in peace. But despite everything, I tolerated all of it. And since November, have been continuing to run the institution till today. But things got beyond my tolerance on the day before yesterday night, when nothing was left unsaid. He treated me like an enemy. Despite coming from a family of teachers, in your belief, I started this business. Today, neither can I go forward or move forward. You have forgotten that you created this institution, and today you are determined to destroy the same. You gave Niloy the task of defaming me from Delhi, and every weakness was given to Vikas Sisodi at Guwahati. I don't need such harassment anymore. It was my mistake. My parents sent me to Guwahati for studies, and I choose a different path. Today, I have no choice but to take this path, unknown path. Mother, I know you will not forgive me, but Dhunu and Aita listen to you. Keep them close to your heart. I have no options left to seek forgiveness from you. Father, accept my last prayer. I could not live up to your standards. Sell the land and repay the loans. The documents are in the office, else in my room. Mutation is left. I could not repay your debt in this life. Tunu Aita, what can I even say to you? Whatever sadness I am leaving you, I hope you can convert it into happiness. Look after months and so and so, so and so. These are things, my lord, goodbye and everything. Now, my lord, will kindly see. Here is a person, my lord, outside the state of Assam, who was a brilliant career, my lord. He has passed out from NET, and thereafter he opened the Infinity. That is a proprietorship concern. Now, in the month of September, his father expired in Jharkhand. So, mother has been left alone. So, mother wants him to come back. For that purpose, an agreement has been entered into. Kindly come to the agreement, page 30, my lord, 3. It starts from page 33. They are talking in the affair, my lord. It's contrary, my lord. This is the agreement. And I have done it because I want to shift myself to Jharkhand to be beside my mother and run similar kind of business in Jharkhand, my lord. This memorandum of understanding MOU is made on this so-and-so. Ankit Kumar, aged over 34 years, my lord. So-and-so, 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 address so-and-so. Herein to a referred expression deemed includes so-and-so, so-and-so. And Paban Hazarika, the person who has committed suicide. Aged 26, so-and-so, so-and-so, so-and-so. Whereas Ankit Kumar was the sole proprietor of a coaching institute called Affinity Classes, who is specializing in NEET, G, and foundation courses. Ankit Kumar has decided to convert Affinity Classes into a partnership concern under the name of Affinity Group of Institutions. The partnership with the involvement of Paban Hazarika as a partner. November, it has been done. Pavan Hazarika will hold 90% of the share in new partnership, while Ankit Kumar will hold 10% of the share. Now, next page, my lord, will kindly see. The parties agree that Ankit Kumar, there's a word, business affinity classes has been converted into a partnership firm under the name Affinity Group of Institution. The partnership will be distributed as follows: 90 that the person committed suicide and 10% mine. And what is the payment mode, my lord? Payment of shares. Pavan Hazarika agrees to pay Ankit Kumar a total sum of rupees 90 lakh INR for his 90% share in the partnership. He agrees. He pays the installment also, my lord. That the payment terms for the total amount of 90 lakhs are as follows: November 24 to May 25. Pavan will pay 4.9 lakhs per month to Ankit Kumar, which he has failed in the later on. Earlier he has paid. Later on it was not paid. In June-July 2025, Pavan Hazarika will make a lump sum payment of 50 lakhs to Ankit Kumar. And for that purpose, my lord, he came from Jharkhand, my lord. And there was a debate with regard to this. And that why you are not paying it? Because he is running that business not on the basis of, my lord, his own money. He has taken loan for that purpose from the bank. So he has to repay the loan. Otherwise, interest is going. And for payment of the loan, my lord, he has not stopped working, my lord. His education qualification, he has used it in Narayana schools as a faculty there. Now, thereafter, my lord will kindly say, after June, July today, the remaining payment of schedule 13 lakhs INR will be discussed later on. It's been part of the agreement. And for that purpose, this has been done. Now, a person who could not take this run the institution, my lord, he never knew he was a good friend. This person who has committed suicide, my lord, this petitioner allowed him to stay at his own house. He applied for NEET exam. He's a brilliant guy, my lord. The person committed suicide. He did not succeed. He applied for any other competitive exam. He did not succeed. Then, because he was good, he was working as a faculty in affinity. He lives with the petitioner. And when petitioner's father expired in September, the dog, that name has been mentioned in the FIR, my lord, that dog has been handed over to him so that he can go and do the last ritual. When he came back, he took back the dog. And that been also been made an issue. Now, my lord, with regard to 306, this case has been registered. For 306, my lord, abatement to suicide, the ingredients of 107 is sine qua non. I participate with regard to abatement by instigating him to commit suicide, or otherwise aid in commission of suicide, or otherwise engages himself into committing suicide. Where are these ingredients, my lord? It's been a transaction that has been done. It's unfortunate a person has died, my lord. It is unfortunate, but by no stretch, my lord, a case of 306 is made out. I rely on a Supreme Court judgment, my lord, wherein interim order was given and it was been allowed to continue. That is Arnab Goswami's case, my lord. 306, my lord, that has been interpreted and been met. Disa kitabkan. Paragraph 49, my lord, will kindly come. Page 462. May I read it, my lord?
Yes.
Before we evaluate the content of the affair, a reference to section 306 is IPC is necessary. Section 30 stipulates that if a person commits suicide, whoever abates the commission of such suicide shall be punishment so and so, so and so. Abatement has been, my lord, quoted, my lord. Illustration has been given. 50. The first segment of section 107 defines abatement as the instigation of a person to do a particular thing. The second segment defines it with reference to engaging in a conspiracy with one or more other persons for doing a thing and an act of illegal omission in pursuance of the conspiracy. Under the third segment, abatement is found to on intensely aiding the doing of the either by an act or omission. These provisions have been construed specifically in the context of section 306, to which a reference is necessary in order to furnish the legal foundation of assessing the contents of the affair. Hence, these judgments, my lord, will kindly come to page next paragraph 52. These are the judgments that's been relied on, my lord, by the Supreme Court. in Madan Mohan Singh versus so and so was specifically a case where arose in the context of petition 482, where the High Court had dismissed the petition for quashing an affair registered for offence under 306 294B of the IPC. In that case, FIR registered on a complaint of spouse of the deceased who was working as a driver with the accused. The driver has been rebuffed by the employer and was later found to be dead or having committed suicide. A suicide note was relied on in the FIR. The contents of which indicated that the driver had not been given a fixed vehicle, unlike other drivers, beside which he had other complaints, including deduction of 15 days' wages from his salary. The suicide note named the appellant accused. Now, ultimately, my lord, it was quashed. Another judgment that has been quoted, my lord, I come to, my lord, yes, paragraph 63, my lord. The petition before High Court was instituted under Article 226 of the Constitution and Section 482 CRPC. While dealing with the petition under 482 of quashing of the affair, the High Court has not considered whether prima facie the ingredients of the offence has been made out in the affair. If the High Court were to have carried out this exercise, it would, as we have held in this judgment, have been apparent that the ingredients of the offence has not prima facie been established. As a consequence of its failure to perform its function under 482, High Court has disabled itself for exercising its jurisdiction under 226 to consider the appellant's application for bail. In considering such an application under 226, the High Court must be circumspect in exercising its power on the basis of the facts of each case. However, the High Court should not foreclose itself from the exercise of the power when a citizen has been arbitrarily deprived of their personal liberty in excess of state power. Now, ultimately, in this Arnab Goswami's judgment, my lord, a last paragraph, my lord, I am reading it, my lord. The court has interfered and allowed the interim order. He was inside jail, interim order, he was released and it was continued. Ultimately, it was quashed also. There is recent judgment of our Supreme Court, my lord, on same point. Our High Court also, my lord. Didiya, Pinta. Tinta, yes. Now, this is Ayub and others, state of Uttar Pradesh, my lord. That note, my lord, 306, my lord. None of the indicators required to make out a case is even remotely mentioned in the search sheet or borne out of the materials on record. There is only one-sided version of the search sheet, so and so, so and so. Ultimately, my lord, there were allegations with regard to harassment, utterance of words. That doesn't constitute, my lord, 306. This is the judgment in regard to this. Paragraph 18, 19, 20, and 21, my lord. And the appeal was allowed, my lord. The proceeding in case number so and so, it was quashed. Same, my lord. For abetting, my lord, a specific overtake has to be attributed. That I aided him by providing a rope, my lord, so that he can commit suicide. I provided my gun, you commit suicide. I am there. Now engages myself in the commission of suicide. I know he is committing suicide. I engage myself in this. Then, my lord, and my lord, instigate. You commit suicide. You commit suicide. Instigate in any manner. There has to be specific overtake attributed as such. In another judgment, my lord, it is different. My lord, this is another judgment of the Supreme Court, my lord. It is Supreme Court or High Court? Supreme Court, my lord. State Mahendra Awasi versus State of Madhya Pradesh, my lord. 306. Hell no, for conviction, that a person who is said to have abetted the commission of suicide must have played an active role by an act of instigation or by doing certain acts to facilitate the commission of suicide. Where is the facility? He lives differently. He is a depressed person. Yes, I want that particular money so that I can pay to my bank. If I am entitled to any money, my lord, is it an offense to ask that particular money on the basis of an agreement, which I have placed before the records, my lord? It is judgment, sir. It is judgment, sir. This is again recent judgment, my lord. 306 and 114, my lord. It would be a copy of that. What took this, sir? I don't know. Anyway, my lord, I am giving it, my lord. Abatement, my lord, with regard to this is a less judgment, and these are the judgment of coordinated bunch. Same suicide note, same he used to harass me, this, that will not consider that way, my lord. Ah, wait a minute. That is 2025, my lord. Patel, Babu Bhai, so and so, so. Appellant were accused of abetting the suicide of anyone who allegedly consumed poison due to blackmail by the suicide of an individual who alleged so and so consumed blackmail by the appellant over compromising photographs and videos. Now, my lord, as per the memorandum of saying, I have to get some money from my colleague. I ask him, why you are not giving me? I have to pay my installment. And there is a quarrel in between. And he goes and commits suicide. No, my lord, this is not 306. If I have abused him, for that 506 is there. If I am to Mari Palam, that is 506 is there, criminal intervention. How 306 is an independent distinct offense, my lord? It is unfortunate a person has lost his life, my lord. But the ingredients has to be there. Considering, my lord, 40 days, and what is my age, my lord, will kindly see. Only 36 years, my lord. No criminal antecedents, my lord. In paragraph 1 itself, I have stated in my petition, my lord, about my lord, my qualifications, my lord. No criminal antecedents, because now Supreme Court has stated in one of the judgment that in every petition, the antecedents of the particular person has to be mentioned in him. He is not a criminal, my lord. He has stated he is present, he said so and so, he is permanent resident, so and so, so and so. No criminal antecedent except with the instant case as such is entitled to so and so, my lord. I have stated everything with regard to my education, qualification, and everything, my lord. He's not a criminal, my lord. I would play with folded hands before this honorable court. 40 days, my lord. These are the cases of our High Court. 30 days, 28 days. They have been less because here further investigation is not necessary. The main thing with regard to this allegation is the affair and, my lord, this suicide note. Rest is not necessary, my lord. And whether this prima facie case made out, my lord, absolutely no. By no stretch of interpretation, 306 is been made out. This is my respectful submission, and with folded hands, I would pray, my lord, will do justice to this young guy, my lord, of 36 years.
Yes.
Lordship, to constitute the offense of abatement, which is provided under section 45 of GNS, Lordship, the 3 ingredients are required, Lordship. A person abates the doing of a thing, who instigate any person to do the thing. Number B, Lordship, engages with one or more other persons or persons in any conspiracy for the doing of that thing. If an act or illegal omission takes place in pursuance of that conspiracy and in order to the doing of that thing, or number C, Lordship, intentionally aids by any act or illegal omission the doing of that thing. Here in the present case, Lordship, the first ingredients, the instigation, and instigates any person to do that act, do that thing, and the last one, Lordship, intentionally aids by any act or illegal omission the doing of that thing. These 2 elements are very present in the contents of that fact. Specific prima facie case is made out against the petitioner, Lordship. And so far as during the investigation, Lordship, the IO has recovered the suicide note. It reveals that the present petitioner, along with other 2 persons, has instigated the victim to commit suicide, Lordship. That reveals. And Lordship, so far as this is a regular bail petition, Lordship, and rest of the thing will reveal from the case diary. So at this stage, I'll insist on calling for the case diary. Lordship, give a date, Lordship, so that we can produce the same, and truth will reveal whether this person is really involved or not. That will reveal in the case diary.
I have made available the suicide note and the FIR, my lord. What else will be there? What else, my lord? 40 days I have been behind the bar. My lord will consider that, my lord. Prima facie, my lord, it's been my impression that prima facie, my lord, a case has to be made out, my lord. A prima facie case has to be made out from the affair and this, my lord. I have a fight with him, and that amounts to harassment. Harassment will not do for 306. I have to harass him. You go commit suicide. you commit suicide. That is not there, my lord. This is with regard to a transaction, with regard to 90% share you have taken, pay the money in time. That's all. So why my detention is necessary? I leave it to your lordship wisdom.
I'll pass the order.
Yes.
I think
Yes, we have already heard yesterday, only two is to clarify any this report in regards to this.
What a point.
Only one document lordship. After the order lordship, I visited the
October.
Twice lordship, not once lordship, twice.
One
the-
document you have submitted
Yes.
day before yesterday.
Twice I have visited the, and the both the time they have given the receipt.
So yes, what is your submission?
Yes, my lord.
Mr.
Otherwise, my lord, that report, from that report, it reflects that on 25/9/24, my lord, petitioner appeared along with the order, copy of the order of the Honorable High Court, my lord. And why at that point of time, his statement was not recorded, that is also, my lord, clarified by the IO.
Why? Why it is not recorded?
Recorded because, my lord, earlier statement which was recorded on 9/9/24, he is repeating the, my lord, the same, my lord, thing. So, my lord, for that reason, my lord, I have stated that.
Money his stand is same.
Yes. So, my lord, after 9/9/24, there is no statement.
Then how can you say it is not the fault of the petitioner, it's the
So,
fault
my
of
lord,
the IO?
Yes.
If he doesn't record the statement, in spite of the order of the judge.
So, my lord, yes, my lord, so my lord, from that order, my lord, from that report, it reflects that yes, he appeared, my lord, on that day. But there is, as because in the case diary earlier, there is no such note regarding whether after, my lord, 9/9/24, whether any statement recorded by the IO or whether he appeared or not. So, my lord, it would be at that point of time, it is difficult for me to ascertain from the case diary actually whether accused person appeared or not. After I clarified the, my lord, from the IO, my lord, then only, my lord, after getting the, my lord, that receipt copy from the police station, then only I came to know that yes, he appeared before the IO. But in the case there, your lordship will not find any note regarding the IO that on 24/9 he appeared before the.
Okay, then that this part is there, then that he appeared before the IO in two occasion, but due to, as you have submitted the reason, for that reason only the statements were not recorded.
Yes, ma'am.
Now the
Otherwise,
question
my
is,
lord,
otherwise the informant
Otherwise,
had
my lord,
appeared
police,
and
otherwise, police cannot force him to, my lord, confess the, my lord, regarding the, my lord, case. Otherwise, police can only record the.
police cannot.
Otherwise,
But
police
there
can.
is a note or there is a, or in the order of the learned decision, that there is a reflection in the order that he is not cooperating the manner he should cooperate.
Yes, ma'am.
That is only.
Otherwise,
Now the other question is that the informant has already appeared with an interlocutory application or an objection that during the pendency of this case or during the period when he was on interim, in that period he made some threatening calls to dissuade.
Yes,
that part.
those materials.
On that regard, you have yesterday you have
regarding his
submitted a report.
appearance, my lord, my stand is clear that he appeared. Yes, he appeared, and my lord.
Okay, Mr. Sharma,
regarding
I'll
other-
pass the order. I have already dictated the order. The last part is there. I'll pass the order.
And regarding other materials, my lord, on that day I pointed out everything.
Yes, everything is noted. Everything.
I'm grateful.
Okay. Itu apa? Pasal nombor. Ini last token nombor.
We never call lordship, that is clear from our affidavit.
You?
We never call the guard lordship after the order. This call over the WhatsApp, we never. We have given an on
It is
what case.
still under, it is still under inquiry or investigation still, because the subsequent, the complaint has been already been taken as a additional, I mean, FIR. So the IO is now working on that inquiry matter. That will be considered as Okay.
Yes, my lord, that is true, my lord. A charge sheet is filed, my lord. That's
have
for
taken
information, my lord.
instructions on-
So, my lord, Kindly, my lord, the TCR may be called for, my lord, to examine by your lordship, my lord. The petitioner one is rejected, my lord. And I have annexed the rejection order, my lord. Kindly have a look
Can we
at the page 50.
Item number 5.
Page 58, my lord. Kindly have a look, my lord.
No, okay, the case has already been charge sheeted.
Yes, my lord, that's not, no, my lord.
So you want to call the
TCR, my
TCR?
lord, TCR.
Whether they have lordship appeared before the trial court after filing CS note.
My lord, what happened, my lord, already to the accused number, main accused number 1, even he is not granted bail, my lord. I have also annexed the rejection order, my lord, earlier. We filed at page 58, my lord. So I.
Okay, we call. Mr. You are AK
AK
Talukdar.
Talukdar.
Mr. AK Talukdar, number 5. The petitioner also heard MS SH Bora, the learned additional appearing on behalf of the state. The next para, it is submitted by MS Bora as well as Mr. Talukdar. The case has already been charged sheeted. Height, CS number, yes. CS number, Bora.
Lordship, white CS number 180
Of 180
of the 2025, dated 9/7/2025.
97.
Lordship.
97.
My lord, GR number may be mentioned, my lord, page number 20, my lord. This is important.
To bring this context, Mr. Talukdar, the done the constitutional submitted that the co-accused of one of the co-accused had made one of the bail petition of one of the co-accused has already been rejected by the trial court widow. And hence, the present petition has been filed for this court. For this, let the TCR be called for. Rest you will do the needful. This the matter.
My lord, their case number may be required, my lord. Page 20, my lord, their case number 543 of 2025, my lord. In the court of CJM.
14.8 will do.
14.8, my lord. 97 days, my lord. Maybe shorter, my lord.
No, we don't have any short yet.
If possible, my lord, for 97 days already, my lord.
At page 11, 12, 13, 14, that apart, we don't have any.
Maybe 12, my lord, if possible, permit,
12
my
is
lord.
almost, many matters have been fixed. I think.
My lord, GR
It's a
number.
hearing day also, many matters.
My lord, GR number may kindly mention.
Why are you insisting on GR number?
My lord, because, my lord, now the case is in the court, my lord, the CJM's court. They are treated by GR number.
We take 14.8. 13, go to 13.8. 13. Oh, 13.8.
Not it.
I'm being reckless. Why are we knowing?
My lord, here in this
Yes,
case, my lord,
what was it? Why it is on?
Lordship, whether CS filed or not, Lordship, that instruction was sought for. So accordingly, we have received the instruction. CS is not filed. CS is pending. Lordship may fix for calling date on the next day after tomorrow, Lordship, for calling for the case study.
my lord,
No, just tell us one thing. He is in 55.
57 days.
57 days in
Not sure.
custody.
Not sure.
Money
Leave it
I
here.
got, my lord.
Think,
Leave it.
My lord,
because 2-3 days may not
Yes,
be
my
possible.
Lordship.
my lord.
I heard Mr. A. Manna, the learned counsel for the petition, and also heard MS SH Bora, the learned additional PP, bring on the object respondent. This is an application under section so and so in connection with so and so. Next para, it is submitted by Mr. Manna that the present accused petitioner is innocent and he is no way connected in the alleged offense. However, the petitioner is in custody since last 57 days and hence, considering his length of detention, he may be enlarged on bail. So, however, he is still ready and willing to cooperate the IO in further investigation of this case. He is granted with the object. Next, para, in this context, MS Bora, the learned additional people, submitted that she made an inquiry with the IO, and it is it is learned that till that the IO could not prepare a charge sheet and case is still under investigation. However, she raised objection and submitted that considering the materials available in the statement made in the FIR, the present petitioner's prayer for bail may be rejected at this stage. Next. Hearing this submission made by learned counsel for both sides and without going detail into the merit of the case, only considering the length of detention already undergone by the present accused petitioner, I find that further custodial detention interrogation may not be necessary for the purpose of investigation. In view of this, I find it a fit case to extend the privilege of hearing to the present petitioner, so and so, so and so. This Kamur Metro,
My lord, metro.
additional CGM,
My lord, it's learned CGM.
CGM
Kamrut
Kamur
metro.
CGM Kamur.
Obligement, highly obliged.
ইফালে নাযাবই আৰু ইফালে নাযায় আৰু আগ নামাৰিব উপায়তো নাই আৰু বাকীটো নাযায় আৰু বেলেগ ক'ত যাওঁ ন
My lord,
yes
he's still on leg in court number 4.
Otherwise, in this case, already I have received the report, madam, regarding registration of any case against the accused petitioner after.
so what is the report as per the report
Your lordship may kindly peruse earlier.
no case
Yes, no fresh case against the, your lordship may kindly peruse.
earlier it was the
Yes, 301/2020. And thereafter, my lord,
we have already reflected these things in the earlier order also.
Yes.
So that case has been there, but
Yeah.
thereafter no other case.
No fresh case.
Is in till now no fresh cases has been against. We'll pass the order. URMS
S. Laskar. S. Laskar.
S. Laskar.
Yes.
Hard MS S. Laskar appearing on behalf of Mr. Hier Bhuyan, the learned counsel for the petition. Also heard Mr. P. Thakur, the learned additional PP appearing on behalf of state respondent. And next, it is submitted by Mr. Thakur that the officer in charge Lahorikat PS has already furnished the report, and it is stated that one Lahorikat PS case number 301/2020 is still pending against the present petitioner, but no fresh case has been registered against the petitioner at Lahorikat police station till date. In view of this, the present petition, the bail application is hereby closed and disposed of. However, the petitioner is at liberty to approach the appropriate forum if any case is registered against him under the against him. Okay. A report received from the police may be kept as a part of the act. May be kept as a
May I please, your lordship?
Yes.
Lordship, this is 482 bail application, lordship, in charge sheeted case, lordship. Allegation against the petitioner is lordship 366, 344 and 341 IPC, lordship. Incident was occurred in the year of 2007, lordship. Lordship, kindly come to FIR, lordship. Page number 11, lordship. And 16 is the Barnacular, lordship. Got it, lordship? Allegation against the petitioner is lordship. Petitioner was confined the message of informant, lordship, and kidnapped her.
So police is searching you now. Now you have been searched by police.
No, lordship. Charge sheet was filed, lordship, in the year of 2023.
Charge sheet filed.
Charge sheet filed, lordship. incident was occurred 2007 and charge sheet was filed 2023, Lordship. After almost 17 years, Lordship. After incident, Lordship, petitioners and accused number 1 also called by the guardian of victim lady, Lordship. And after that, they heard from them. And they also detained accused number 1 and hand over to the police, Bleshipura police station, Lordship. Actually, fact of the case is, Lordship.
So you are not the accused number 1, or who are you?
Lordship, I am the accused number 2 and 3, Lordship. Accused number 1 was arrested and he also released on bail, Lordship. And last date of the Lordship, next date is, Lordship, fixed 10/9/2025 for appearance, Lordship. Lordship, my
how
humble
you are
prayer
in-
before your Lordship. At this-
Why you are, why the case has been charged again? You are shown as an absconder.
Yes, Lordship.
I
But
mean, you are,
Lordship,
how you are related?
but Lordship, after registered of the case, Lordship, we also meet the informant and guardians of the victim lady, Lordship. And after meet the informant, Lordship, accused number 1 also detained them and hand over to the police. And Lordship, we also returned from there. And after that, Lordship, no information is available with us, Lordship, whether cases filed against us or not, Lordship. And we are the name accused or not, Lordship.
You are the name accused.
Yes, Lordship.
It is suspected that his wife may be sold in the red light area in Delhi or Haryana.
Yes, Lordship.
It was the case.
That's Lordship. Lordship, in FIR kindly. What is Lordship FIR? সম্মানপূর্বক বিনীত নিবেদন এই যে যোৱা 8/7/2007 তাৰিখ ৰবিবাৰ দিনা অনুমান 2টামান বজাত নিম্ন লিখিত পদকীয়া গুণে মোৰ স্ত্ৰী মিছ নুৰভানু বিবিক নানা ধৰণৰ প্ৰলোভন দেখুৱাই ঘৰৰ পৰা অপহৰণ কৰি লৈ গৈ কোনোবা অজ্ঞাত ঠাইত গোপন কৰি ৰাখিছে। প্ৰকাশ থাকে যে 1 নং পদকীয়াজনক যোৱা 16/7/2007 তাৰিখে সোধপোছ কৰাত ঘটনাৰ বিষয়ে স্বীকাৰ কৰাত উক্ত পদকীয়াজনক ব্লেচিপাৰা থানাত চমজাই দিয়া হয়। My humble prayer before your Lordship, charge sheet has been filed, Lordship, and petitioner will be appeared before the.
You are saying, you are mentioning the sections as 366, 344, 341.
Yes, sir.
But the order speaks otherwise.
But Lordship, charge sheet.
Say materials against 366, 376D is there.
Yes, Lordship. Charge sheet.
Then gang rape is
Charge sheet was filed to edit the 366D, Lordship.
376D.
376D, Lordship.
Then how can you say that your involvement you were not aware of? Because 376D is there.
Yes, Lordship. But charge sheet was filed in the year of 2023, Lordship, after the 17 years of incident.
That is understood. That's a long 17 years.
Yes, Lordship.
Okay, let us call for the
But-
case. Case
But in
record.
this stage, Lordship, I think custodial interrogation is not necessary, Lordship.
No, interrogation will not be there. Against you already charges has been filed. But we had to see whether you were.
Charge was not
cooperating-
framed, Lordship.
No, not that. We are to see whether your custodial detention will be required, whether there is any probability of absconding, whether there is any your involvement, this much only. Otherwise, custodial interrogation, question of custodial interrogation is not there. You are not being questioned by the police now. We just want to see your cooperation, how whether you were cooperating or not.
Yes,
That
Lordship.
has
At
been
this
because
stage,
you are
Lordship,
saying that you were not aware of, but the I don't know, because 376D is there. So there cannot be any case that you were not searched by police. I don't know. That's why the case is there, because otherwise 344, 366 was okay. But
Lordship,
now subsequent it is seen that
at this stage,
376D is
Lordship,
there.
at this stage, Lordship, my humble prayer, petitioner will appear before the court below, Lordship, that some protection may be given to the petitioner, Lordship.
You were summoned or
Summon, Lordship.
summoned?
Yes, Lordship. We have received summon on, Lordship.
Issue Harry corridor. This is the informant is made party here, no?
Lordship, government is approved.
Government is on.
Yes.
Call for the simple call for the scan copy of the PCR along with the case diary. distribute duty report, list the matter accordingly on 18th of August, 18th. Your case is fixed on 15/9.
Yes, it's fixed on lordship 10/9/2025.
10/9. We are listing it on 18/8. Let us see.
18/8 lordship.
Yes, it.
Obliged.
13 people. 13 people. That order was there. Suppose we say 13. Huh? I think 15. Yes,
Your
Mr.
Lordship. Lordship, FIR, your Lordship will find page 14. This is the typed copy, Lordship. Typed copy of the vernacular. May I read? Lordship? Here, Lordship, just before reading that last part, your Lordship will find that name of the informant is there, age is there, 24 years.
Abida.
Yes. সন্মানপূৰ্বক বিনীত নিবেদন এই যে মই লেংটিচিঙা উচ্চতৰ মাধ্যমিক বিদ্যালয়ৰ দ্বিতীয় বৰ্ষৰ ছাত্ৰী হওঁ আজিৰ পৰা অনুমান 6 মাহ আগৰে পৰাই 1 নং আছামীজনে মোৰ মোবাইলত ফোন কৰি মোক ভাল পোৱা বুলি কৈ নানা ধৰণৰ অশ্লীল ইংগিত দিয়ে আৰু মোক বিবাহ কৰাব বুলি কোৱাত মই অমান্তি হোৱাত মোক নানা ধৰণৰ ভয় ভাবুকি দি থাকে যোৱা 15/5/2025 ইংৰাজী তাৰিখত মই পুৱা 8 মান বজাত ঘৰৰ পৰা বিদ্যালয়লৈ আহোঁ আবেলি 2টামান বজাত মোৰ মূৰৰ বিষ ও শৰীৰৰ Victim is a major girl and it is said that it was from the in front of school, which probably is not possible. And both father and son.
She got married with the one.
Yes. That I have stated in paragraph 4 also. Because of that missing report, police came and subsequently took her back. And thereafter, because of the pressure from her family member, this present affair was done. Last 5 line, your Lordship will get that about marriage part, paragraph 4, page 4. The petitioner number 1 then took the victim because obviously Lordship pressurized the petitioner number 1, so he took her. Major Lordship that.
Yes, but.
Lordship, this is merely a statement that he has married the victim girl. So far as FIR is concerned, that is not revealed, but see, he has married the girl. And Lordship, and the contents of the FIR reveals the fact that he has forcefully committed sexual assault. Established forcefully, Lordship, that is there. So at this stage, Lordship may call case time. Now with the 183 PNSS.
And probably father and son both together will not involve in such
As far as
case.
the father's is concerned, I have got no objection. That accused number 1. I've got objection.
In fact, she got married with the father, not the son.
Lordship, that's it finds to be quite creepy, Lordship.
Yes.
So that's a call for the case diary 183 statement of the victim.
And that's it.
Should it be called for?
And some protection may be given, Lord. That is because she is major. Otherwise, also, I would not have space for it.
Specifically,
Just 24-year-old girl.
yeah.
And she has also stated that since last 1 year that stalking part is there, she has never lost any complaint or anything.
Lordship, she has specifically implicated petition number 1, accused number 1, the boy. And in the statement of the petition, he has stated that a marriage was took place with the father, Lordship. So who is who is the actual
the boy?
No, with father.
Affair was having with the father.
Father only.
Yes.
So
affair was with the
not
father.
an interim magistrate.
Even FIR also says that father was having affair.
Mr. A. Ahmed, learned concept petitioner, not part its assist for the learned petitioner PP on behalf. This is an application, section in connection with simple point of considering the submission made by the considering both the petitions, both the petitioner and the respondent, as well as comments made in the allegation made and the contents of the considering the contents of the FIR. I find it a fitness to extend the privilege of interim pre-arrest bail to the petitioner number 2, namely Azizul Haq. But the prayer for interim pre-arrest bail for the petitioner number 1 is not considered at this stage. And let the city be called for or Buckingham report is provided. Do number of DTP. Okay, under 2 will be under interim protection. For 1 we are calling the case diary.
Not.
18 19 to khula nahi bondo. 19 is the working day. Either maybe on 18 or 19. Prior to that, we don't have any dates. 18. List one.
Lordship is given interim protection.
Interim to 2 I have given.
Son.
1, his father is the main.
No.
You are misleading, not the son. She got married with the father only, not with the son.
Lordship are directed to appear before the ILO.
Yes, number 2 will definitely appear. And for number 1, we are calling.
Obliged.
17, 16, 9. 16 mentioned. He will. It's 16. See, he's someone. Mention who is. You know, Macron. 17. ইমানে কিন্তু কৈছে এতিয়া কম আৰু কমাব পাৰিব আৰু এটা মই কাইলৈ কম কৰিব পাৰো নহ'লে চিএপি কামে কৰিব সময় মেইন প্ৰব্লেমটো হৈছে কালিতো অৰুণাচল বেঞ্চ এটা অৰুণাচল মেটাৰ বাকীবিলাক মেটাৰ 2টা বজাত জিবি কি চাই লওঁ 17
May I please, Your Honor? Lord, it's a short affair. My lord will please to find at page 8. This is regarding voluntarily causing grievous hurt. My lord will find at page 8.
Yes.
May I read, my lord? With due respect, I beg to state that today me and my younger brother, after finishing my work, came out of Gossip Sky and Bar for our home, and at that time, near ABC Point, 2 unknown people misbehaved with us and hit us, and as a result of which my younger brother was attacked with a knife and was admitted at GMCH. So I humbly request you to do proper investigation on the matter and provide justice to my younger brother. So in this case, one person has been accused, one accused person has been arrested. My innocence will transfer from that forwarding letter itself, my lord. My lord will please to find at page 14. Brief facts of the case, my lord. The brief facts of the case is that on 17/7/2025, one complainant, Nikita Priyadarshini, lodged an affair stating that she is an employee of Gossip Sky Bar on the early morning on 17/7/2025 at around 4 a.m. when she and her brother were returning home after completing their duty. That time at ABC, two unknown persons were there, and one of them misbehaved them and stabbed their brother, hence the case. So there were 2 persons, but one of them misbehaved them and stabbed. And reason for arrest, my lord, the arrested accused person stabbed the victim on his abdomen and made the victim grievously injured. Immediate after the incident, the victim had to immediately admit at GMCH to save his life, and still he is admitted at GMCH for his recovery. And next, my lord, the arrested accused person has accepted his guilty that he had a fight with the complainant and his brother, where he physically assaulted both complainants and his brother and finally stabbed the victim, brother of the complainant. So there is no whisper in the reason for arrest that this present petitioner was mere present there. He didn't do anything, my lord. So that is the only case.
Yes, for any.
Lordship, because
You will be
injury
under
was
interim
serious.
protection then. Otherwise, if we go by the this according report, there is, I think in the case record in regards to the any implication to the other person. Going to part Mr. BM Deka is an concept. Also part SH Bharat is an application. Yeah, BM on campus. This is an application under section Swenson in connection with Swenson. Next, considering the submission made by the running counsel for the petitioner and the and the statement made in the FI as well as in the grounds of arrest for the other co-accused, and find that it is to extend the privilege of interim period to represent this petitioner till receipt of this. Okay, will be under interim protection. Appear
Much obliged, my lord.
IO and CD we call for along with the medical. We are calling for the CD and the medical report. Cooperate with the investigation.
My lord.
Listed on 2929. Well listed.
29. Much obliged.
Wait, please, your lordship. Lordship, this is a pre-arrest bail application, lordship. We have the student of lordship, fifth semester of lordship, radiography and advanced technology of the Royal Global School, lordship. Now, lordship, kindly come to the page 11, lordship. Point number 6, lordship, the details of the informant is given, lordship. Her date of birth is given is 2000, lordship. Now, the incident occurred on
Whose date of birth?
2025 at
Whose date of birth?
the informant, lordship.
Informant's date of birth.
Yes, lordship, victim. 2000, lordship. Now, incident occurred, lordship, 2025. It seems that she is a 25 years old lordship. Girl, lordship. It is page 13 is the FIR, lordship. May I read the FIR, lordship? Informant herself, lordship. The victim herself lost this FIR, lordship. It is respectfully submitted that since last 1 year, I was in love relation with the accused number 1, and the accused number 1 in the pretext of love took me to his house in a different time and cohabited with me against my will, and then he captured the photos and videos in his mobile. Then the accused number 1 started blackmailing me and with those photos and videos and compelled me to do as per his wish. On last 27/6/25 at about night 2 a.m. Can you see the time, lordship? The accused number 1 took me from my house on the pretext of marriage and forcefully raped me. On next early morning, the other accused person saw me in their house. Then they caught hold my hair and assaulted me. The accused number 1 fled away from the place of occurrence. Then the accused number 2 outraged my modesty and ousted me from the house and locked their main door. Thereafter, all the accused person of the house fled away. The accused person threatened me that if I visit their house again, then they will kill me. Accordingly, lordship, this case was registered under section attempt to lordship punishment for rape, that is 64 and 74 for the outrage of modesty, lordship, and criminal intimidation and common intention, lordship. All the family member has been made an accused, lordship. 2 and 3 and 4, lordship, approached before the court, lordship. They were granted anticipated bail by the court below, lordship. Now, lordship, what happened? This petitioner had a relation with this girl, lordship. Kindly come to the para 5 in my page 5 of this petition, lordship. She want to marry this boy, lordship, and the boy is pursuing course, lordship. That's why she is not in a position to marry that girl, lordship. Now, what happened on that night, lordship? She suddenly appeared before that girl, boy's house, lordship, and the other lordship, the accused person, lordship, they throw her out from that home, lordship. What happened, lordship? She called the media person. Now the private media is there, lordship. They come up there, and they have showed the picture, lordship. They, in front of them, they are saying, lordship, she is protesting against that boy because of that. He is not going to marry her, lordship. If it's a case of lordship, rape, lordship, she would not have come, lordship, before the media, lordship. It's an absolutely concocted story, lordship, just to hamper the reputation of this boy, lordship. Is pursuing course, lordship. As no, lordship, this course required, lordship. Just page 26, lordship, will find the great sheet of the, let's say, result
of this present petitioner lordship, page 26, is just completed lordship with fourth semester in 2000 June 25 lordship. Now lordship is pursuing to sixth semester lordship. Just to hamper him lordship, this girl lordship force her to marry at this time lordship. He is now not in a position to marry the girl lordship, but she is well acquainted that lordship. The consequence she knows lordship, even that she is in love with this boy lordship. Because there is a voluntary consent is there lordship, because otherwise she will not come at that time lordship in the house of this petitioner lordship. Absolutely false case lordship. Because of that lordship, now this boy on run lordship.
The allegation of blackmailing with the photos and videos are there. These are serious things, my lord. And the session just found that no incriminating material against the other accused. But the petitioner anticipatory bail was not granted by the session judge. Session judge, after perusal of the CD, found that there are no incriminating material against the other accused, but against the petitioner is there. So lordship will call for the case diary at this stage, my lord. And the
Where
next
is the order of decision?
That is
Page
the annex
27.
lordship, page
27.
27 lordship.
Page 30 is the
30 is the
last paragraph.
Xerox
Last
copy
paragraph.
lordship.
Page 30, last paragraph. The 183 BNS statement of the victim reflects strong privacy material against the accused petitioner number 1, Abu Bakr Setti. Accordingly, PRS bail of the accused petitioner number is rejected. The 183 statement of the victim do not reflect sufficient incriminating materials against the other accused petitioner so and so, so and so. So their bail petition was granted, their bail was granted, but the bail petition was regarded as sufficient incriminating material. And FIR itself reflects that he has taken the videos and photographs of the victim's guard, my lord, and it was maybe published, my lord, and blackmailing is there. So at this stage, in respect of the petitioner number, this petitioner, my lord, lordship cannot consider interim protection.
Lordship, what happened in this case, lordship? Only she has given the 183 lordship a statement under 183 BNS lordship. She has not gone for medical examination lordship. Till date lordship, she has not been medically examined lordship. That can be recorded lordship, my submission lordship. As per instruction lordship, till date she was not medically examined lordship. Absolutely false case lordship. In video also lordship, in the social media I have that video clips lordship. She has not stated that she has been raped lordship. This I have with my mobile phone lordship.
Mr. B. Chaudhary, Dealer counsel for the petition. And also Mr. J. Sutia, Dealer petition PP. This is an application, section so and so, in connection so and so. Next paragraph is submitted to Mr. Chaudhary that concept from that allegations has been brought against the present petitioner. He is a student of BSc 6th semester and pursuing his study in Royal Global University, Guwahati. Royal Global University, Guwahati. It is the fact that he has a love relationship with the victim, but who insisting him to marry her, but the petitioner was not in a position to marry the victim. Now his refusal only, the present FIR has been locked with some false and concocted allegations. More so, on the day of incident at about 2 a.m., petitioner forcibly entered into the house of the informant entered into the house of the petitioner, and on refusal to keep her or marry her, she created a scene, called for the media person, and accordingly, the FIR has been lost. However, he will cooperate the IO in further investigation of this case if he is granted with some interim. Next paragraph, Mr. Sutia, the learned additional PP submitted in this regard that the sufficient incrimination, no, there is sufficient, not sufficient, there is submitted that the considering the, no, sorry, submitted that the learned session judge had rejected the anticipatory bail prayer of the present petitioner after perusal of the case diary and considering the statement made by victim under section 183 BNSS. Though The other petitioners were granted with the privilege of anticipatory. Accordingly, Mr. Sutia submitted that this CD may be called for to know the actual facts. Next, Mr. Chaudhary, the learned counsel for the petition submitted that as per his instructions, the girl has not yet gave her consent for medical examination, and she only implicated him in her statement under section 183 BNSS. Next, considering the entire circumstances of this case, submission made by learned counsel for both sides, and other aspects of the case, I find it difficult to extend the privilege of interim pre-arrest bail to the present petitioner till receipt of the case type. So and so. Okay, it will be under you will be under interim protection, cooperate with the
Highly obliged. Highly
It's on
obliged.
9-9. We're listing it on 9-9.
Obliged.
May I please the lordship. Here is the bail application lordship. FIR page lordship 9 lordship. May I read lordship?
Yes.
With due regard, I would like to inform you that I am a resident of the below mentioned locality and by profession a businessman. That on 2/11/2022, I have given my Ishar Piero TG White so-and-so engine, VDEX so-and-so, chassis number so-and-so, C. Mokibur Rahman on lease agreement for a period of 3 months. With regard, I like to inform that Mokibur Rahman in the month of January 2024, due to the vehicle engine failure, had left it at Lidu, Bamagar, Sakila Basti, and few days later he informed me about the condition of the vehicle with the verbal assurance that after repairing the vehicle, he will return it from the hilly place to me. After few days, I had called him over phone, but he did not receive my call. He did not want to meet me and also stay away from me. But as per agreement, he had not returned the vehicle to me till date. After inquiring a few days later, I came to know that the vehicle is at the said hilly place. Thereafter, I took an engine mechanic for repairing the vehicle, but failed to do so. Even after trying hard to repair it, in this way, many days passed away. Today, on 26, 2025, I went to the said place with the intention to bring the vehicle by pulling it, but the vehicle was not in the same place. Then, on inquiring the local neighbors, I came to know that some persons of Margarita, namely Avinash Pradhan, Manav Phukon, Anil Agarwala, Tarakeswar, together came in a Maruti Wagoner bearing so-and-so with a recovery van bearing so-and-so, driven by Real Bahadur Thapa, and another recovery van bearing so-and-so, driven by Sri Basant Panika, had stolen the Isar vehicle. After inquiring, I came to know that the vehicle was taken for cutting in dump of Sri Arun Shah at Escaping Avenue, Tinsukia, Lordship. And petitioner brought against allegation only for stolen the vehicle, Lordship. Actually, petitioner man is Avinash, Lordship. Accordingly, he went to the said place, Lordship. After
What they say? Yes, your petitioner is?
petitioner is a friend of the Avinash Pradhan, Lordship.
Achha.
Avinash Pradhan asked him to come to see the vehicle, Lordship, purchase vehicle, Lordship. Accordingly, he went to their Lordship. After the
To purchase the vehicle.
Lordship, Avinash Pradhan purchased the vehicle, Lordship. He told the petitioner, Lordship. After that, petitioner went to their Lordship, said place, Lordship. And he saw the vehicle. Vehicle was Lordship mechanical defect, Lordship. And he came back to his own place, Lordship, petitioner. That is the actual fact, Lordship. But petitioner name has been implicated, falsely implicated, Lordship. Already prime accused has been arrested by the police, Lordship.
Who is the prime accused?
Prime accused, Lordship, Avinash, Lordship, Anil Agarwala, and Tankesa were arrested, Lordship.
But as per the FIR, you 3 or 4 are the same footing.
No, Lordship.
No, as per the FIR.
Yes, Lordship.
As per the FIR, you along with these 3-4,
Yes.
you together went there.
Lordship.
And the allegation also that with some recovery when those were carrying. And then it was cut and after making it so and so, and then it was dumped in the one scrapping avenue.
Petitioner stated Lordship, paragraph 4, Lordship, kindly see the bail petition, Lordship.
Yes. What you have stated?
Lordship, petitioner, Lordship, Avinash Pradhan, who is a friend of the petitioner and had told the petitioner that he passes a dumper vehicle.
That is your submission. It is
Yes, Lordship.
Yes.
Otherwise, he is a FIR named accused person, Lordship. City.
Lordship, kindly,
Otherwise, your submission it was okay, but the question is that you along with the other 4, 5, 3, 4,
Lordship.
you together went there.
Yes,
That is the FIR.
Yes,
And
Lordship.
thereafter you
they have stolen the vehicle.
stolen the vehicle by through recovery van and all.
When the
And that-
vehicle was stolen, that was the time petitioner is not there, Lordship.
But as per
But
FIR, you were
FIR is
there.
concerned, he is doing that.
As per the
Actually,
FIR,
name
you
is
were there.
also wrongly put the FIR, Lordship. Actually, name is Manavjyoti Fukan, Lordship.
City will reveal, Lordship. It's anticipatory. bill.
But you are saying that you were not there,
Lordship.
or you simply visited and see the vehicle only,
Lordship.
which was been purchased by Pradhan.
Lordship.
But
Lordship, kindly protect me,
FIR
Lordship.
shows otherwise.
At this stage, Lordship, kindly protect me, CD will reveal it, Lordship, whether I have involved
It
or
will
not.
be
Lordship.
revealed, but for intent protection, there has to be something. No? It's not there anything. It's only your verbal submission that you were not there, but as per the FIR, you were there.
Lordship.
Okay, we are calling for a case diary. 19-8.
Lordship.
CTP call. Can copy.
May
you
I
are-
please, your Lordship? Lordship, I am appearing on behalf of Mr. A. Fukan, amicus curiae. Lordship.
Amicus, A. Fukan.
Yes. Lordship, amicus curiae on legs. At port number 4, your Lordship. So maybe taken after some time.
It's already 3:25. I don't know how many times
Lordship,
or what time.
10 to 15 minutes later.
Few minutes. Okay, we'll sit.
Obliged, Lordship.
Time being হয়ে যাচ্ছে। নহয় time being। Hmm? 22 क्या है? Why 22? 25.
My lord, item number 22, your lordship may lose into flag X. Flag X in item number 22. My lord,
Flag?
X. Flag X has been marked in that petition. Item number 22.
No, we're not taking item number 22.
I just heard from.
That's just, it's a mistake on his part.
Oh, sorry.
মাতাও এনেকে উল্টা পুল্টাকে মাতিলে দিগদাৰ হ'ব ন। কিয় 25 টো কিয় বাদ দিলে? খবৰ সময়
26, 27 minutes.
26 and 27 his diary receipt.
Take this matter after some time. My senior is engaged in.
Time I cannot say, but your senior may be engaged in other court, I don't know, but time may not be there. It may be adjourned. Okay. Yeah. Call for 28. 28 month. 26, 27, this is taking time. We're keeping it, but I don't know, it may not reach also because there are many matters, lots of the matters will be left over here. That's right.
Then lordship 5 minutes may I call the senior.
You can, you directly, but Mathematics. 28 and 29, both
Hello.
matters. You
My
are
understanding will start 29, then I'll work on 28. Can it 29?
you are appearing on 29.
29. So she will find the FIR as page 12.
29 to 29. FIR is at page 12.
12 plots.
Here we have received the case diary.
Case diary received.
Here in this case, Lordship, the present petitioner is from a different financial institute. The allegation is that the employees, two employees, mainly one branch head, he has this financial institute, they are dealing with a gold finance.
Gold finance.
Gold finance. So the allegation is that the customer who deposited the gold were misappropriated by the branch head and assistant branch head. I'm working in a different institute. Now,
So allegation of misappropriation of gold.
lots. Sir, my Lord, Senior Counsel will argue the 20.
Which one it is? 20?
28.
28.
28.
Let him complete the 29 then.
Yes.
He's arguing on 29.
Since he has started, my lord.
Yes.
Oh, sir, sorry.
So allegation of misappropriation of the gold.
Gold which were deposited by customer. And I'm not the employee of that institute where the gold were deposited. I'm employee of a different institute, although they deals with the same type of business.
You are not the employee.
I'm not employee of the institute from where the gold were misappropriated. The customer's gold were misappropriated. It was Aravind Microfinance, where customer deposited gold for loan. And the branch head and assistant allegation is that branch head and along with the assistant branch head, they misappropriated the deposited gold. They deposited in the other financial institute and took loan. So may I read the FIR first? I so and so. I can skip the first paragraph, which is not much relevant. Second paragraph, I am writing on behalf of Ashirvad Microfinance Limited, a registered non-banking financial company, to report a serious incident of suspected robbery and criminal misappropriation of customers' gold at our Dhekiajuli branch, so by the branch employee. This issue was discovered during an internal audit, which is currently going on. As per the audit finding, till now the customer placed 19 gold packets are found to be affected, specifically packet details attached in annexures. 7 packets are found to be entirely missing from the vault, and 12 packets have been tampered with and replaced with fake and fancy jewelry items. The total estimated gold weight evolved rupees so and so grams, and the approximate financial loss has been assessed at my market value of 74 lakhs 49,100 so and so. Please note that this is an approximate figure, and the total loss may increase as further audit and reconciliation progresses. Details of employees suspected and missing. So and so, the current branch head was responsible for branch operation at the time of discovery. Address so and so. He has also disappeared without notice, is not reporting in or to duty, and is avoiding all contact. Now, second, Mr. Kuldeep Deka, my senior counsel is appearing from Kuldeep Deka. Deka, who served as an assistant branch head, was transferred from Dhekiajuli branch just 3 days prior to the discovery of the fraud. Address so and so, so and so. On verification, it was found that no damage is caused to safe and it is opened by using original key is kept in custody of branch head, assistant branch head. So it is strongly believed that the misappropriation and cheating was committed by branch head Mr. So and Mr. So. The simultaneous disappearance of both the employees along with the unauthorized vault activity strongly suggests a pre-planned criminal conspiracy and abuse of their official position for personal gain. The facts of the case clearly indicate that the two individuals entrusted with the safekeeping of the customer assets have, instead of committing theft and criminal misappropriation of pledged property, the replacement of the original pledged gold with fake items suggests pre-planned misconduct intended to cause financial loss to the company and its customers. So I'm not named in the FIR. I'm not an employee. I'm not in. So I was arrested because my forwarding report shows that page 16 forwarding report that these two persons, especially the branch head, that Moon, he misrepresented the pay. Because this company, Ashirvan, it was for 80 days, it was shut down for some financial irregularity. At that time, this head of the branch, Moon, the accused number 1 in the FIR, he misrepresented the fact to me and said that he has purchased this gold in auction. And these are the gold of non-performing account. So on prima facie, I believe that fact, and I have opened the account for loan by depositing that gold as mortgage. That is the allegation. Lordship will find that in the forwarding also.
You mortgaged the loan.
I'm employee of a different institute.
Then?
This head of the branch, Moon Ali or something,
Moon
Ahmed, he brought some gold along with some customer, saying that those gold were purchased during auction. And those gold are from the non-performing accounts. And he represented those gold has to be purchased from during auction. So he, along with some customer, he came to my institute, he deposited gold and he took loan on behalf of those customers. That is what is forwarding also reveals. I'll take your honor to page 17, Lordship. That is the forwarding. I'm for 30 days, 36 days. I'm a lady, Lordship. I'm 36 days in custody. Forwarding reveals that page 17, Lordship got it. Page 17, second paragraph. After arrest of Kuldeep Deka, that is present petition, his interrogation revealed that some of the stolen gold packets Ashidvar Microfinance Limited were illegally deposited in IIFL gold loan by Moon Ahmed with the help of accused Ria Paul and Kuldeep Deka. Ria Paul is the present petitioner and he is an employee of IIFL gold loan. As per the statement, she had developed a friendly relation with Moon Ahmed, that is prime accused, when RBI had stopped operation of Ashirvad Microfinance for a period of 80 days following MFI of higher rate interest. At that time, accused Moon Ahmed had provided some gold loan customer to Riyapal, that is the petitioner. Later on, Moon Ahmed gave her several packets of gold in multiple occasions, showing that these gold packets were NPA, non-performing asset account, and that these gold were procured by him on auction. So I was misrepresented the entire fact. This Moon Ahmed, the prime accused, who is named accused and head of the branch, and he is having the all keys and everything of the pledged gold. He misrepresented the fact. He said that these gold are of non-performing asset and he has purchased this in auction. Believing his statement, I have opened the account, I have deposited the gold and I gave loan to the customer. Performing asset accounts and that these gold were procured by him on auction. However, the SOP as stated by official of Ashirvad Microfinance Company Limited clearly restrict the employees to participate in the such auction. Although there is an official guideline that no employee should purchase the auction gold, but I was not aware about that guideline. As such, it was clear that although the accused Ria Pal claimed her innocence, she was aware of the fact that the accused Moon Ahmed, whose salary was around so and so, cannot afford to purchase those gold in auction. In confession of Ria Pal revealed that the gold packets was kept in her maternal house. On the other hand, 6 other gold packets were kept in IIFL gold loan, the Kiajuli branch, where she was employed. The gold packets in her possession has been seized on Iman as per seizure. So it was, which was in my custody was recovered, and the other 6 packets are in custody of that institute, financial institute. That account has been freezed. My account has been freezed. I could not apparent my account. So there is no possibility of misappropriating the account. I'm in custody for 36 days. The gold which were in my possession were recovered, and other 6 packets of gold are in custody of the financial company. And most probably, as of now, the police has seized those gold packets also. So my humble and respectful submission, Lordship, my further custodial detention may not be necessary, Lordship. I'm a lady, Lordship, I'm for 41 days I'm in custody, Lordship. And I'm not involved in stealing or misappropriating the gold. It was done by the prime accused, named accused person. And by misrepresenting the fact, prime accused person has involved me in this offense. So kindly consider my bail application, because 41 days a lady, Lordship, and most of the investigation part is over. My account has been freezed. Gold has been recovered from my, and with whatever was in my possession, it was recovered. And other thing was in financial deposition of the financial institute.
We can hear one by one, or you can, we'll submit together.
My lord, let my complete, then finally I will submit them.
Yes, Mr. Doctor, you can.
So far I am concerned, I am on behalf of Mr. Kuldeep Dekami. Now, the prosecution case is that on 11/6/2025, complainant, that is a regional head audit of Ashirbad Microfinance, lodged a complaint before the Dekajuli police station that, my lord, they suspect that employees of Dekajuli branch has misoperated the customer's gold. Now, after that, my lord, this issue was discovered during an internal audit. 19 packets of gold were found to be a fake one, exchanged by the fake, my lord, packets, and 7 packets found to be missing. Now, this is the allegation. Your lordship has seen the FIR. Once again, I will take your lordship to that. That page 14, my lord. Is dated 11/6/2025. Page 14, your lordship got it. In the middle part, I am writing on behalf of Ashirbad Microfinance Limited, a registered non-banking finance company, to report a serious incident of suspected robbery and criminal misappropriation of customer gold at our Dekajuli branch. This issue was discovered during an internal audit which is currently ongoing. As per audit findings, till now, the customers placed 19 gold packets are found to be affected. Specifically, packet details attached as annexures. 7 packets are found to be entirely missing. Now it has been recovered now from the vault, and 12 packets have been tampered with and replaced with a fake or fancy jewelry item. The total estimated gold weight involved 888 grams, and the approximate financial cost would be 74 lakhs and odd. Now, the details of employees suspected, they are number 1, Moon Ahmed, then 2, Kuldeep Deka, there is the petitioner here. Now, at present, my lord, Moon Ahmed possibly absconding, but so far the petitioner is concerned, I went to the office on 16/6 to cooperate with the audit department. On that date itself, my lord, I was arrested. And till such time, my lord, your lordship will find that I have been in custody. Today it is 44 days. Now I will take your lordships to page 26, my lord. This is the order dated 17/6/2025. The relevant part your lordship will find at page 28. Last but one para I'll read. Considering the submission of the IO, the nature of the offense alleged, as well as for the sake of proper investigation, the prayer of IO, the police custody is allowed for 3 days, only for the purpose of finding clues about the missing placed gold of the public. Then your lordship may turn to page 31, order dated 19/6/2025. Accused is produced before me by the IO concerned. Accused means Kuldeep Dekka. After completion of 3 days of police remand, seen the forwarding inspection memo, medical document of the accused and the relevant pages of the interrogation register, heard so and so. On being asked, the accused stated that he was not tortured by the police. It also appears that the accused is also provided with regular medical checkup, food, etc. And the IO followed the direction as per so and so. Now, IO has paid for judicial custody of the accused. My lord, so far the custodial interrogation, possibly it was all over within that 3 days. So therefore, they are not asking for any further for custodial interrogation. Now, the other part of the thing is that is regarding Riyapal, as my learned friend has already argued on that. Now, the entirety of the thing, my lord, so far interrogation is concerned, custodial interrogation is all over. So therefore, my lord, the rule, as your lordship knows, that bail is the order of the day, is not jail. So therefore, my lord, it should not be that an accused is not supposed to be in custody with the object of punishing him on the assumption of his guilt. My lord, there are decision of the appeals court. My lord, I will take your lordships to that. I will take your lordship to a few paragraphs. Yes, ma'am. Your lordship may come to paragraph 21 to 25. ma'am. This is at page 63 possibly. Paragraph 21, has the lordship got that? In bail application generally, it has been laid down from the earliest time that the object of bail is to secure the appearance of the accused person at his trial by reasonable amount of bail. The object of bail is neither punitive nor preventive. Deprivation of liberty must be considered a punishment unless it is required to ensure that an accused person will stand his trial when called upon. The courts owe more than verbal respect to the principle that punishment begins after conviction, and that every man is deemed to be innocent until duly tried and duly found guilty. From the earliest times, it was appreciated that detention in custody pending completion of trial could be a cause of great hardship. From time to time, necessity demands that some unconvicted person should be held in custody pending trial to secure their attendance at the trial, but in such cases, necessity is the operative test. In this country, it would be quite contrary to the concept of personal liberty enshrined in the Constitution that any person should be punished in respect of any matter upon which he has not been convicted, or that in any circumstances he should be deprived of his liberty upon only the belief that he will tamper with the witnesses if left at liberty, save in the most extraordinary circumstances. Apart from the question of prevention being the object of refusal of bail, one must not lose sight of the fact that any imprisonment before conviction has a substantial punitive content, and it would be improper for any court to refuse bail as a mark of disapproval for former conduct, whether the accused has been convicted for it or not, or to refuse bail to an unconvicted person for the purpose of giving him a test of imprisonment as a lesson. The instant case, we have already noticed that the pointing finger of the accusation against the appellant is the seriousness of the charge. The offences alleged are economic offences which have resulted in loss to the state exchequer. Though they contend that there is a possibility of the appellants tampering with the witnesses, they have not placed any material in support of the allegation. In our view, seriousness of the charge is no doubt one of the relevant considerations while considering bail applications, but that is not the only test or the factor. The other that also requires to be taken note of is the punishment that could be imposed after trial and conviction, both under the penal code and the prevention of so and so. Otherwise, if the former is the only test, we would not be balancing the constitutional rights, but rather recalibrating the scales of justice. The provision of CRPC confer discretionary jurisdiction on criminal court to grant bail to the accused pending trial or in appeal against conviction. Since the jurisdiction is discretionary, it has to be exercised with great care and caution by balancing the valuable right of liberty of the individual and the interest of the society in general. In our view, the reasoning adopted by the learned district judge, which is affirmed by the High Court, in our opinion, is a denial of the whole basis of our system of law and normal rule of bail system. It transcends respect for the requirement that a man shall be considered innocent until he is found guilty. If such power is recognized, then it may lead to chaotic situation and would jeopardize the personal liberty of an individual. Then the last para, my lord,
Otherwise, you accept your guilt, that you were also involved.
My
It's
lord,
the principle, I know.
yes, so far the prima facie case, your lordship has seen, my lord, the FIR shows that they were involved. Now, they are saying they suspect that they may be involved in this. Now, so far the custodial interrogation is concerned, it is all over. So therefore, my lord, keeping him in the jail, it is in the supposition that he might have committed that. And the intention of the legislature is not that the accused should be kept in bail because it is the apprehension that they might have committed that. So this is the, my lord, outline of this judgment. Then para 40 also, your lordship. Para 40 can be just that page. Paragraph 40, my lord. The grant of refusal to grant bail lies within the discretion of the court. The grant or denial is regulated to a large extent by the facts and circumstances of each particular case. But at the same time, right to bail is not to be denied merely because of the sentiments of the community against the accused. The primary purposes of bail in a criminal case are to relieve the accused of imprisonment, to relieve the state of the burden of keeping him pending the trial, and at the same time to keep the accused constructively in the custody of the court, whether before or after conviction, to assure that he will submit to the jurisdiction of the court and be in attendance thereon whenever his presence is required. Now, my lord, only your lordship is to see whether his presence can be assured. Now, my lord, I have volunteered myself to cooperate with the audit department. Now, there itself, I was arrested. That shows that, my lord, my intention is there to cooperate with the, my lord, the investigation and all. Yes. And that, my lord, your lordship has seen that in the yes. Because our case is that, my lord, we went there in the office on 16/6 and the police arrested from there itself. So therefore, my assurance to be present when the trial starts, my lord, it is already guaranteed. So therefore, on that score, my lord, since the custodial interrogation is not required, even if it is required, my lord, my presence is assured. My lord, therefore, at this period of time, the lordship may be kind enough to grant bail, since the custodial interrogation is possibly all over. That's right.
Yes.
Yes, yes.
May I please, your lordship, my lord, in this case diary received, my lord, FIR is lodged by the, my lord, Asirvad Microfinance Company Limited, my lord. And my lord, total amount of financial loss of the company is 74 lakhs 49,135. My lord, here the present petitioner Kuldeep Deka is the assistant branch head of the, my lord, that financial company, man. And one Moon Ahmed, who is the, my lord, branch head of the company of Thekiajuli branch. Now, my lord, what happened? Those, my lord, goals are, my lord, of the customers. What they have done, my lord, they, my lord, misappropriated the gold of the customers, my lord, and thereafter, my lord, by way of, my lord, how they misappropriated those golds, my lord, during investigation, it reveals that it's some gold by, my lord, by changing some of the golds from the, my lord, vault area, my lord, they kept there some fancy items, my lord. And thereafter, my lord, during investigation, it comes to light that who are the person, my lord, who are the custodian of those, my lord, vault area, the present petitioner, Kuldeep Deka. And there is, during, my lord, one, my lord, CCTV footage is also there, my lord, during investigation, it comes to light that on examination of the CCTV footage of Ashirvad Microfinance Company, Dekiazuli branch dated 35/2025, accused Kuldeep Deka was seen taking out 2 gold packets from the vault room and concealing in his pockets of the pen worn by the accused Kuldeep Deka. And there is no tampering of the, my lord, digital lock. So, my lord, while there is no tampering of the digital lock, who are the custodian, the present accused, my lord, Kuldeep Deka and Moon Ahmed, and the from the CCTV footage also it reflects that this is Kuldeep Deka who kept out those 2, my lord, gold packets, and my lord, and thereafter taking out, my lord, those gold accounts from the, my lord, digital locker, my lord. And your lordship, what happened in this case? Thereafter, my lord, here from the state bank account of, my lord, Moon Ahmed was also collected, my lord. That is State Bank, SBI, my lord, bank account. And from the bank account of Moon, although, my lord, the Moon Ahmed is not a petitioner, he is now, my lord, absconder, my lord. And from the bank statement of Moon Ahmed, and there are, my lord, lots of transactions between, my lord, huge amount, my lord, from between Kuldeep Deka and Moon Ahmed, my lord. And also, my lord, Ria Paul. And my lord, immediately after the incident, when, my lord, about the incident comes to the knowledge of the, my lord, financial company, my lord, thereafter from the next day itself, Kuldeep Deka was hiding, my lord, and Moon Ahmed till now, my lord, he is not yet traceable. And my lord, after arrest of Kuldeep Deka, my lord, from his statement, it revealed that he has kept some of the gold items of Ashirvad Microfinance Company Limited, which were, my lord, deposited to IIFL gold loan. And the Riapol, man, who is Riapol? He is a gold appraiser of IIFL gold loan. And thereafter, my lord, on the basis of the statement of the Kuldeep Deka, when, my lord, police interrogated Riapal, from the, my lord, from Riapal, my lord, from her statement, it reflects that police recovered total 7 packets of gold items from Riapal, my lord. And from his statement, I would just like to point out one relevant, আজি কেইদিনমানৰ আগতে মাইক্ৰ' ফাইনেন্স এছিষ্টেণ্ট ব্ৰাঞ্চ হেড কুলদীপ ডেকাই মোক 2টা সোণৰ টোপোলা দিছিল। সেই সোণ দি মোৰ স্বামীৰ নামত লোন চেংচন কৰিছিলোঁ। দিছ ইজ দ্য এবাউট ৰিয়াপল। যদিও মাইক্ৰ' ফাইনেন্সত সোণৰ খেলি মেলি ধৰা পৰা বুলি গম পোৱাৰ পিছত টকা ঘূৰাই দি সোণখিনি মোৰ মাৰ ঘৰ নং 10 নম্বৰ চোৱেঞ্চ শান্তিপুৰাত ৰাখিছোঁ। দেয়াৰ আফটাৰ police has recovered all those 7 packets of gold items, and Caesar list is also available. So in this case, my lord, how the 3 persons, my lord, Moon Ahmed, Kuldeep Deka, and Riapal, all these accused persons in connivance, how they misappropriated those gold items of the customer, and those gold items were deposited by the, my lord, those customers for taking loan, and those gold items were kept in the custody of the vault area of the Ashirvad Microfinance Company Limited, and the custodian is, my lord, Moon Ahmed and Kuldeep Deka. And from the CCTV footage also, my lord, there are illegal, my lord, some illegal activities that how he takes out those gold items from the vault area, my lord. There is also CCTV footage is also there, and how he, along with, my lord, Moon Ahmed, my lord, bank transaction is also available. And thereafter, my lord, recovery of 7 packets of gold items from the IIFL gold of Riapol, my lord. So everything, my lord, discloses how they are involved in committing such, my lord, huge amount of committed, my lord, misappropriated such a huge amount from Ashirvad Microfinance Company. That is an amount of rupees 74,49,135. And thereafter, police also, my lord, recovered all those, my lord, gold. They not only, my lord, kept out all those gold items from the, my lord, vault area of the microfinance company. They also, thereafter, they sold some of the gold items, and thereafter, by depositing some of the gold items in the IIFL gold of Riapol, my lord, they my lord, thereby they facilitated taking loans in the name of some unknown customers from my lord IIFL Gold Loan, who is my lord, one of the my lord appraiser of that IIFL Gold is my lord Diapol. So all are in connivance, my lord, committed the offense, and thereby my lord, this my complainant company has got huge amount of loss, my lord, 74 lakh, more than 74 lakh. There are my lord, sufficient materials against all these accused.
My lord, the submission made, my lord, these are all, my lord, subject matter of trial. So, my lord, my learned friend hasn't said anything whether the bail can be granted at this stage or not.
Well, how can I say that? Well, it is the privilege of your lordship. My duty is to point out, my lord, from
No,
the.
these are all subject matter of trial. The trial will take its own, my lord, course. Well,
Considering the materials in the case record, whether do you think that further custodial
Other
interrogation
from
will
the
be
materials,
necessary?
my lord, from the still, my lord, one Moon Ahmed is not
Still
yet there.
abscond.
Yes, some recovery is also there, my lord. This is not only 7 packets of gold item. Only 7 packets of gold item recovered from Riapal on the basis of the statement of Kuldeep Deka.
7 packets of gold items were recovered from Riapa,
Total amounts
and
gold
the
packet, my lord,
other
12 packet.
some packets were recovered from the IFL also.
IFL gold loan, my lord, that is the appraiser of the IFL gold loan is Riapal.
No. From the
No.
IFL gold loan company, also they some packets were recovered from there. No.
Yes, no, from Riapol recovered, my lord, on the basis of
From from the position of the Riapa, 7 packets were recovered.
Yes,
And from the from her company, that is the finance company of IFL.
Oh, yes. From the IFL company also, 1 packet of please gold of IFL finance, 1 seizure list also of IFL.
1 packet.
Yes.
Only 1 packet.
Thereafter, 1 packet of please gold of IFL finance Juli branch by GL number containing chain of, my lord, 3 numbers of chain.
No, that
Total weight.
we cannot say now 3 numbers, how many numbers.
Yes.
The question is that there were I mean, with some original fake gold, with some fake gold and artificial intermediate jewelry.
Yes.
19 packets were misappropriated,
Yes.
and 7 packets were missing.
Yes.
7 packets, and under 19 packets were also missing, but 19 packets were replaced by some intimation
Fancy items.
jewelry and all, artificial jewelry and all.
Those are
No,
some
I'm
fake-
saying that
fake gold.
7 packets were recovered from the position of Riapal,
Riapal.
and the rest of the packets, out of 19 packets, which were also missing, out of that, how many packets or what is the
My lord,
recovered?
only 1 packet from the seizure list, my lord. 1 packet from from the Juli branch of IIFL, my lord.
1 packet.
1 packet. And
Page 17, what you will find in my petition. On the other hand, 6 other gold packets were kept in IFL loan. 6 packets.
6 packets.
6 packets. Gold packets were still lying in the IFL loan. Some golds are lying in the Ashirvad gold itself. It was shifted by intimate fake jewelry.
That as per you, how many
yes, my lord,
packets you
there are
have
6
received?
seizure list, my lord.
How many packets you have received? As per you,
7.
your company, how many packets?
6 packets. As per forwarding report, 6 packets are lying in the same company where I am employed. IIFF.
No, from your maternal house or paternal house, somewhere.
7 were recovered, seized and recovered from my maternal house, and 6 packets are lying in IIFF.
That is on the basis
Total
of the
30.
statement of Riapol, those, my lord, which were kept by the Riapol, those from the maternal house of the, my lord, Riapol. So ultimately, my lord, those recovered from the possession of the Riapol, my lord, on being released by her, my lord, those packets were recovered from the maternal.
That is good. Whether custodial interrogation is required.
Because, my lord, main accused, my lord, Moon Ahmed not yet arrested. And from bank transaction also revealed that there is coordination between all these 3 accused persons.
29 to 29. Hard Mr. Jet Alam, Learned Council for the Jet Alam, Learned Council for the Hard Mr. B. Waterfalls, CD receipt, parents. It is submitted by Mr. Alam that the present this petition is not the employee under the Ashirvad Microfinance. No? Ashirvad Microfinance Limited, and she is an employee of another finance company that is IIFL. Then she further admits that the present petitioner, being an employee of so and so, had received some packets of gold as it was submitted by which was produced before the said company by the accused number 1 Moon Ahmed, stating that those packets of gold he had already purchased on auction, and purchased on auction. Purchased on auction, stating that these are the non-performing assets. With that stipulation, some of the packets were deposited in the said company of IIFL, and some customers were also provided with loan. Who you provided loan to whom?
To the customer.
Customer. Provided the loan to customers. But subsequently, she also came to know that those were the gold which were misappropriated from the Ashirvad Microfinance Limited. Under the under the impression that those gold packets were purchased by Moon Ahmed on auction, and the loans were provided for those gold packets. However, during investigation, 7 packets of gold has been recovered from her possession as per the seizure list, and 6 numbers of packets are still lying in her company, that is IIF. She further submitted she extended her cooperation in the investigation of this case. And I got this sufficient opportunity to interrogate her, even keeping her in police custody. She is a lady and she already in custody for last 41 days, and hence further custodial interrogation may not be required for the purpose of investigation. However, she is ready and willing to extend her cooperation in further investigation of this case if she is provided with privilege of it. Next paragraph. Mr. Botaku, the learned additional PP, submitted in this regard that there are sufficient incriminating materials against the present petitioner, who being an employee of another finance company had extended her cooperation in misappropriating the gold which are missing from Ashirvad Microfinance Limited, and from her position,
My lord, by depositing after taking those Ashirvad companies, my lord, 6 packets of gold, she deposited in the IFL, and from her statement it reflected he took loan in the name of her husband by depositing those gold. That is her statement. After taking those golds from Ashirvad Microfinance, she deposited those golds in IIFL and took loan in the name of her husband.
Let me allow very after he further submitted that from the materials available in the case data, it also reveals that after obtaining the gold from the Ashirvad Microfinance Limited, she obtained gold loan in her name of her husband, and thus she she is also involved in misappropriating the gold packets which were missing, alleged to have been which are missing from the Ashirvad microfinance company. Further, he submitted that as per the allegation, 19 packets of gold was also replaced with by some artificial jewelry and tempered with some replaced by some artificial and fancy jewelries, and all the gold packets are yet to be recovered, and which were misappropriated, alleged to have been misappropriated from the Ashirvad Microfinance Limited. The further submitted, there was a huge transaction of money between this the parent petitioner along with the other two co-accused persons, and considering is the nature and gravity of the offense, further custody interrogation may be required for the purpose of investigation. Mr. Waterford accordingly raised objection, submitted that it may not be a fit case to extend the privilege of bail to the present petition. Next, এবার একটু লোকে হাবদান পর বাকিখিনি মই চাই আছো submission can record করলো next 28 heard Mr. S. Doctor, the learned senior advocate, assisted by Mr. P.K. Deka, the learned counsel for the petitioners, and also heard Mr. P. Bota, the learned additional PP appearing on behalf of the suspense. Next point, sitting submitted by Mr. Doctor, the learned senior advocate, that the present accused petition is innocent and he is no way involved in the alleged offense. However, coming to know about the misappropriation and missing of the gold from the finance company, he himself volunteered and he herself volunteered and cooperated in the audit, wherein his name has been entangled in the present case. He further, Mr. Dr. further submitted that the present accused petition is in custody since last 44 days, including the 3 days police remand. From the order passed by the learned trial court below, it also reveals that after 3 days of police remand, there was no prayer for further custodial interrogation by police for the present petitioner, and since 44 days, he is in judicial custody. Mr. Doctor further submitted that there is the matter has sufficiently there is sufficient progress of the investigation, and hence further custodial interrogation of the present petitioner may not be required for the purpose of investigation. He further submitted that citing the decision of Honorable Apex Court reported in 2012 1 SCC page 14, he submitted that that the provision of CRPC confers the discretionary jurisdiction on criminal courts to grant bail to the accused pending trial or in appellate stage, and it has to be exercised with great care and caution by balancing the valuable right of liberty of an individual and the interest of the society. He further submitted that it is a settled position of law that uh, that the bail is a rule and the jail is an exception. He further submitted that that a person may be put into the into the jail pending trial only to secure their attendance at the trial at the time of trial or at the time of investigation. But here in the instant case, the present petitioner himself surrendered, volunteered, and appeared before the audit committee, and also cooperated in the audit while there was an audit account. And thus there is no probability of absconding of the present petitioner who appeared himself before the audit committee and is still ready and willing to cooperate the IO in further investigation. Next, pardon. Mr. Bothakur, Illinois Edition PP submitted in this that the that as per the allegation, when the audit was done in the Ashirvad Microfinance Limited, it was found that 19 packets, now I did 12 packets. 7 packets of gold was entirely missing from the vault, and 12 packets have been tempered with and replaced with some fake or fancy jewelry items. The present petitioner was also the custodian of the vault, custodian of this ink corridor.
Vault area of the microfinance.
Vault area of the said microfinance company, and it also reveals that without any damage on the vault area or the lockers, the goals were misappropriate or missing from the vault area. Thus, he is fully involved in the alleged offense, and there was a huge transaction of money between the parties. 7 pockets of gold were already recovered from the possession of one of the co-accused, Priya Paul. However, and 6 packets were found lying in the office of the other finance company, IIFL, but the other packets are yet to be recovered. And one of the co-accused, which is also considered to be one of the prime accused of this case, is still absconding, and he could not yet be apprehended. He could not be apprehended by police till yet. And hence, considering all these aspects of the case, the gravity of the offense and the stage of the investigation, the further custodial interrogation of the present accused petitioner may be required for the interest of the investigation. Accordingly, he raised objection and submitted that may not be a fit case to allow the accused petitioner to go on at this stage. I have noted down your submission, pass the order. এনে বাকী হৈছে অকমান খালি লিপা কটাত যাব
Whether it'll pass over the case, case diary.
case diary may not be required because there are sufficient distinct materials in the forwarding report also I can say.
Our part was hard, my lord, that actually.
Your part was hard.
Yes, my lord, that is better relating to your lordship. Second application earlier, it was rejected by your lordship, my lord. That is
Oh yes, some it has been written down.
Julia case, Julia PS case, my lord. Where Mr.
Just to brief you, there's a suicidal.
Suicide, yes, yes. See, initially, there was a suicide, my lord. Thereafter, they converted into a case of murder, my lord. Based on circumstantial evidence, my lord. Report of the examiner.
Two postmortems, well. I'm appearing for the amicus here, well.
Postmortem report was there.
Javed used to appear for the.
The first one was not done properly, my lord. So the second postmortem was had to be done, and the CID was the CID had taken over, my lord. Then the second postmortem was done, and my lord, the subsequent the second postmortem, my lord, a lot of things which were left out in the first postmortem that was highlighted, my lord. And my lord, I'm appearing as the amicus on the last occasion. Mr. Hassan is the special PP. He had argued at length, my lord. And my lord, last occasion I had come for the first time, my lord. So your lordship had given me some time to go through.
Other day, the Mr. Hassan was there.
Mr. Hassan is there, my lord. He had argued at length, my lord, on the last occasion.
Oh, you are the amicus.
I'm the amicus.
Achha.
And my lord, minor things I would.
She was a maid servant or
my lord.
She was a maid servant.
Maid servant. Now I can remember. Yes.
And my lord, I just.
So you are appealing for the informant victim.
Informant
At the
victim.
moment, my lord, I've been appointed because the previous distinct no one appeared. So. My lord, page 49, my lord, which is the medical report.
Justice. Page 49.
Page 49, I would like to show, my lord, the injuries in the body, my lord. There was no injury in the body detected on the body during the first autopsy except the ligature mark of hanging. 49.
Only ligature mark.
Ligature mark. Then, however, during the second autopsy, it is revealed that the scalp on the left parietal area measuring 7 centimeter and 4 centimeter and left temporal area measuring 10 centimeter and 4 centimeter found to be centrally bluish green in color, surrounded by a pale yellow zone. Underlying these areas, there is a staining over the corresponding skull bones. On examination of the photograph provided, it is found to be consistent with the findings of the second autopsy report with evidence of collection of the blood in the layers of the scalp with staining of the skull in corresponding area indicates antemortem injury caused by hard blunt weaponry. This has to be taken into consideration, my lord. In the first autopsy, this thing was not highlighted, and they have compared both the autopsies, my lord, whereas both are, my lord, comparing comparatively similar, my lord, which is given. However, this particular thing was missed out in the first autopsy because it was not done properly. This, lordship, I am pointing out to your lordship, my lord, that there was a sign of, my lord, injury, aggravated assault, my lord, and my lord, there was which shows that there was an injury caused by a hard blunt weapon. Page 49. And my lord, regarding the the second, since it's the second bail application on the new ground which they have come in, my lord, which is which they have given at the paragraph 21, my lord. The petitioner was arrested and signature was taken in police custody over some documents, but he was never served any notice as mandated by law. Even secondly, neither the petitioner nor any of his relatives or friends was informed about the grounds of any arrest. Whereas in this case, my lord, I would like to say this is a very unique case, my lord. It's a very sensitive case, my lord, because of murder of a 13-year-old girl, my lord, a minor girl, my lord, and also 13-year-old girl. And in this case, my lord, interestingly, my lord, he has surrendered before the police. It is not a case of this thing, my lord. He was when a person surrenders, my lord, it implies that, my lord, my lord, that that person had knew fully well, my lord, that he had done some wrong, my lord. And my lord, if your lordship sees the other medical report, the blood and cement stains were found in this thing, my lord. And my lord, the person had surrendered himself. He has given, my lord. So that also lordship should take into consideration, my lord. That he had that my lord will take into consideration. That there was that is why he surrendered. Otherwise, there was had he not this thing, my lord, he would have not surrendered like that. Generally, in most cases, we find like that. That is, my lord, one of my submissions, my lord. And I also, my lord, rely on the judgments, my lord. Lordship has also given in, my lord, Pramod Saxena, my lord, and my lord, Rajesh Ranjan, my lord, 2004 7 SCC 528, wherein Lordship has held, my lord, relied on the judgments, my lord, where long period of incarceration jail would not be per se be illegal, because in sensitive cases, my lord, this is a fit case, my lord, where, my lord, grave offense has been committed, my lord, and my lord will take that into consideration and not, my lord, grant bail, my lord, in this kind of. That will be my humble submission. Rest I leave it to the Lordship, and also, my lord, the learned PP will be addressing the other issues. Special people.
Today.
My lord,
May it please your lordship, Mr. Hassan, he is in Dibrugarh today. Your lordship, this matter was fixed on 17th. However, the court didn't sit that day. So, your lordship,
Matter was fixed
on the 17th of July. No, the court did not sit that day. Your lordship was in the division bench.
Oh, it was on listed on 17th of July.
Yes.
Otherwise, there was some, there was a submission made by Mr. Hassan also, which we have recorded. But I don't know, there may be further submission on his part that I don't know. But the submission which already have been made by Mr. Hassan was already recorded. It is noted down. By rest, I don't know if anything is there.
Your question.
He wants to make further submission in that regard.
No, your lordship, it was heard at length. So, your lordship, only if the learned counsel for the petitioner makes any new submission today, then the right to reply.
That
your
no,
lordship.
I cannot say that.
Yes,
How can-
yes, your lordship. That's
How
the
can-
only.
Otherwise, we
Yeah,
have
yes,
also
obviously.
heard Mr. Potoki also at a length.
It
And
was
Because
Hassan
it was
was, but
not
the
that he was not.
amicus
Amicus Curiae
was
was not.
not there and he was not prepared. That's why it was kept. But I don't know if any further submission is
No,
there.
no, no.
Mr.
That is for our case is basically. I will just have to reiterate again that basically it is a case of circumstantial evidence. There is no eyewitness to the occurrence. And second question is that out of there were altogether 96 witnesses are there. Only 30 witnesses have examined, and I'm in custody for more than 3 years. 3 years, 1 month. We don't know how long it will take. And there is no question of apprehension of that I will tamper with the evidence. These are all official witnesses, scientific officers, post-mortem report, doctors. These are all and other witnesses. Also, the question of any trade person is not there, my. So my release shall not anyway affect the trial of the case. And now, so far as the post, I don't want to go to merit of the case at this stage because we don't know, because second court post-mortem report was based on photographs. And photographs, because it was a decomposed body.
Yeah, admittedly.
Yes. So how far that is admissible, that will be looking to after subject to cross-examination. We don't know. And there is a change of custody also, there is fault is there. So whether that report, DNA report can be relied upon or not, that is also doubt. So these things, on the merit, I'm not making any submission at this point because it will carry, it will affect the trial of the case, man.
Now, you are representing Mr. Hassan, but the question is that otherwise submission have already made, we have noted down. But the question in regards to further custody, what Mr. Kotopi has pressed, because he is in custody for 3 years and so on, but otherwise now just Mr. Fupon has raised that the period of length of detention may not be a factor would be considered for such kind of cases or nature of heinous offense. That is one aspect. But now he has submitted that till now about more than 30 witnesses have been examined, and the rest of the witnesses maybe from the official witnesses. So in that regard, if Hassan is to submit anything, because he is most probably is also trial, he
Yes,
is also
yes, your lordship.
appearing before the trial judge. Resto, I have already noted down if you want to submit anything
Yes,
because
your lordship, then this matter may be fixed on any day next week.
next week though, we are not in a position to fix any date.
So as your lordship deems convenient.
So he is now, today he is out of station.
Yes, yes, your lordship.
40 to 54. সেরকম একটা বেলেগ CDP দিন না কেন? 48. See, we have some difficulty next week. We know all things. 8, we are not fixing date also. I'm listing less numbers of matters and still 7 lists are full. So next week, if you go by the next week, then 11, 12, and 13 are almost full, but maybe 13 or 14th of August. Will it be okay, Mr. Kotak? He is
14,
in
we make
custody
it 14,
since
sir.
last more than 3 years. Let it be again for custody for another 14 days.
Yes, ma'am. Holiday.
Otherwise, I have nothing to actually.
Or if you want to make that, you can make a written submission also if lordship. Lordship will reserve toward judgment. If you want, because
No, your lordship, I'm not in a position to say anything on that behalf. So your lordship, let it be on the 14th of August, your lordship. Because I have no.
Or
information at
do
that
one thing, if 14, suppose in any case, because we have heard this, Mr. Pukon, we have also heard Mr. Pukon also. So if anything to be submitted in that regard, because there is no other new submission. only
I'm also,
submission
I'm
made
nothing much more, Sami.
by Mr. Kotoki that most of the vital witnesses are already been examined. The rest are mostly official witnesses.
Official
So,
witnesses, sir.
there may not be any question of hampering or tampering with those official witnesses. That is the one aspect, but the merits is different. So in that regard, if anything submission is there, you may have a talk with this one, Hassan also. And then you submit. If Hassan is not available, we'll hear you. In that, only so that point only. And rest, if anything is there, then we can. We're listing it on 14 because we don't have any alternative today. So we're listing it on 14, we'll hear to it and dispose of the matter on 14 itself.
Much obliged.
14 is going to list on. Hardly come. Hard, hard Mr. P. Kotoki, Dilan Constitutive Petitioner, and also hard Mr. MS, you are MS?
MK Brown.
MK Brown appearing on behalf of Mr. J.A. Hassan, Special PP Assam, and also heard Mr. P. Pukan, the amicus, learned amicus appearing for the respond number. Release the matter accordingly on 14/8/2025 for further hearing. We make it at quarter so that it matter may come before this.
Yes.
Obliged.
That is all, okay. That's item number 52, my lord. In this is the orders matters, this IA for extension of time to appear before the IO, my lord. But today, and my lord, interim was granted till today, my lord. Therefore, my lord.
52.
My lord, I was for the informant here.
Just
52, my lord. But what happened, my lord, in the order, interim order, my lord, lordship imposing conditions that within the 7 days of time, I have to appear. And accordingly, my lord, there are two petitioners, my lord, petitioners to appear before the IO on 14th of this month. On this same day, my lord, another affair has been lost by the same informant. And accordingly, police has registered the case under non-bailable section and the petition number 2 has been arrested. Later on, my lord, CGM has released him and the petition number 1 before your lordship appear to your lordship by filing another AV. And lordship has granted the interim protection on last Thursday, my lord. And now, my lord, already 7 days has been elapsed, my lord. My interim protection has been
So
granted.
why in this AB in connection with AB 1535, we could not appear.
This is I could not appear because due to the another affair has been lost. In order.
52. The interim was still today.
Interim was still today, and my lord, there is a condition F. Condition is that the petitioner shall appear before the IO within 7 days from the date of this order, failing which the pre-arrest bail would be left by influx of time. Petition number 1 could not appear before the IO.
Order to close.
That is at page 10, my lord. And
page 10.
Page 10, my lord. In the IA.
Why this petition is before this court? This is passed by the coordinate bench. Only one gun was there. A gun was there. Otherwise, I am a
This case,
I
my lord,
have-
I am filing this way, IA for extension of time to appear before the.
how can I extend?
My lord, because at that time,
Because this was not passed by me, by this court.
my lord, this is the coordinate bench of your lordship, my lord.
Whatever can it be?
My lord, this bench is not available now, my lord. This is the
I
vacation.
don't know. You should approach the registry in that case, because this extension someone has with the judicial approach. This order has been passed. So now how can I extend this one? Extended it, how can it be?
My lord,
It cannot be extended by this court now.
My lord, that code is not available. That is.
Don't know.
My lord, then my lord, otherwise. my-
Suppose modification, alteration, extension, this has to be before that particular court only. Otherwise, hearing is we can hear the matter, no bar. If court is not there, if criminal bench is not taking, we can take. That is okay.
No, actually what happened, my lord, in this meantime, my lord, another case bail, another bail
No, I
was
cannot
granted by
say,
your
but the
lordship.
extension, how I can give the extension to you?
Then my lord, my interim may be extended and I,
That's what I'm saying. How can interim be extended?
because,
CD received in this case? Then CD also received.
my lord, because my lord,
My lord, I am for the informant also. We raise objections also here. He is threatening, he is violating this bail order also, my lord.
Bail order.
He is threatening to this informant, my lord, for which we again lodge a complaint to the police station, which I received also. You received by police station.
that is,
For his threatening only.
Yes, my lord.
my lord, what to do now? My lord, this bench is not available. My lord, I have filed my lord, this kind of.
So otherwise also you violated the terms and conditions as per the
No,
informant.
not my intention, not intentionally, my lord. This is the situation demand.
No, you have violated the terms and conditions that you have not, you are threatening those witnesses or the victim.
No, my lord.
That
in
is
this
one of
situation-
the, condition.
No, one.
You have already violated.
No, my lord. Actually, there are two petitioners, my lord. Petition number 1 and petition number 2. Petition number 2 was appeared before the IO. After lodging this complaint, my lord, petition number 2 was appeared before the IO. And at that time, my lord.
এটা কাম কৰক বেলেগকে একো নোৱাৰে আৰু এইটো কৰিব নোৱাৰে এই বিতৰণ
Yes, Your Honor.
it is kind of better you should approach registry. This is not the way na how can it is
Then, my
passed
lord,
by
this matter may be.
Justice Surana. It cannot be.
My lord, then, my lord, this matter may be placed before that court, my lord. Appropriate bench, my lord.
How the matter may be placed before the appropriate bench. However, till next date of listing. However, for the ends of justice, till next date of listing, the interim order dated 10/7/2025 is hereby extended. List accordingly as on a date to be fixed by the registry. Okay. At best, that much I can do. Should I keep this one with record or what? Have you filed any objection there?
No.
No, what is this?
These are the complaints which he has logged there. Or threatening.
Of threatening.
He has violated the bail order. He is threatening the second petitioner. He is threatening me. When I-
So these threatening calls and all, it has come with the case record, case diary. It is already there. So we'll peruse this one, case diary. And in suppose in any condition, it has to be taken up by this court or another court, then definitely it will be looked after. Till now, we just extending your interim.
Yes.
And as on a date to be fixed by the registry, that will be entered in. And in the meantime, you try to, because if there's any violation of the order of the court, then your interim may be vacated as well.
Oblige, your lordship.
Yes.
Today's 55 days.
Sorry, we are not bypassing any of it.
My lord,
26, 20?
My lord.
26 and 27. On Monday.
26 and 27 was there, but you were not there.
So I am in the court now.
I
pray for item
34, he is behind the bar.
No Monday. This week.
55 days.
Item 34 behind the
You are not going to list any matter.
My lord, item
You
number,
may approach the registry and take a date.
my
there
lord,
from
item
there.
number
We are
25
not
has
in a
been,
position to list any matter on the next week. We are busy otherwise.
my lord, item number
That's all.
25 is bail application only on the grounds of arrest, and which has been crossed, other applications has been taken up, my lord.
Item 34
Come on,
behind the
later.
bar. Item 34.
So,
yeah, he's in the 43 days, my lord. 49 days.
leftover matter. is
Item
left for
33, your lordship. Item 33, 87 days, 60 days mandatory. my lord.
We approach the registry, so list it soon. so that
Monday, it may
mandatory
be
paid-
33 item.
We are not listing, we are not giving any date. You better to,
Interim
these
order.
are all leftover matter.
Interim orders, item, in item 40.
There, if there are any, will take into consideration. By, if there is any entry.
Item number 13 में maintenance को extend करा है